All right, good morning, everyone. I'm Judge Oberliesen. This is our in-custody pretrial conference date. I do have a list of attorneys who've signed up. Let's get started with Jason Cobb. Mr. Cobb.
It never happens that I'm first on the list. So.
I could probably attest to that for you if she doesn't believe me.
You can. Eddie Hudson. Judge, this is State of Florida versus Eddie James Hudson, 25 CF 133, 24 CF 741. I've talked to the state, and I believe we're going to be able to resolve this, but we're not going to be able to resolve it today. I'm asking if we can put on Monday for a plea.
State, who's on Hudson?
Yes, that's correct, Your Honor.
Plea for Monday? May 5th at 9 o'clock. Mr. Hudson, we'll see you back on that day. I'm assuming Mr. Cobb will probably see you before then. Get that shored up, and then we'll see you to resolve your case on Monday.
Yes. Judge, this is State of Florida versus Trace Marshall, 23 CF 1981 and 2019 CF 1607, which is a VOP. That's set for a motion hearing on May 29th, and so I'm asking for a pretrial following the May 29th date.
Have y'all had a chance to talk about the motions? The
We
motion
have.
to sever and the depositions?
We have. We're going to have
With the state, I mean.
I have. We're going to have a hearing, but I think in the interim up to May 29th, there's a possibility we may be able to resolve the cases. So.
Okay.
That's accurate, Your Honor, so we have no objection to that, and we can address it on file.
Okay. All right. It's one of the good things about the new civil rules. It really requires that to happen on most motions, and I think it's a great idea to be able to require people to talk about things in advance. So, but
Yes, sir.
obviously you guys are doing that. I just wanted to check up on that. So you're asking for the June 24th date? Or is the pretrial, otherwise it's still 5/29 for the hearings, motion hearings?
When I get that number, I'll come see you for sure.
Yes, sir. Thank you, Mr. Cobb.
You're welcome.
Thank you, Mr. Oberliesen.
That'd be Judge Oberliesen. Judge, State of Florida versus Kevin Russell. Jason Cobb on behalf of Mr. Russell. 3 cases, 24 CF 119, 2020 CF 915, which is a VOP, and then 23 CF 2611, which is a VOP. You executed the order transcribing, allowing me to get the depositions transcribed. I spoke to Lisa Dempsey yesterday. She's going to have those to me this week, but I have a motion to suppress that I've drafted, but I want to attach the depositions to it because I think we'd be able to resolve the motion just based on the depositions and not have a long, lengthy, drawn-out hearing. But I am
On the
asking.
other side.
I am, Your Honor.
Okay. Were you there for the deposition?
I believe so.
Okay.
Yeah.
I know we all do a lot of cases, and sometimes I look back and stuff that we did 2 weeks ago, I just don't have any memory until I look at it again, and then it
Yes, sir, we
triggers.
did Zoom depositions.
Okay.
Yeah.
All right, I mean,
I'm
has
asking
the
for-
motion been filed?
I have it drafted.
Okay.
I'm just waiting for the transcripts to include with it.
Okay, to attach or to kind of
Attach to it.
sprinkle through, look at line number?
Exactly, so I can reference it and plug in everything.
Understandable.
But this would be
Want to get
the,
a tentative hearing date for that?
yeah, I can do that. That'd be great. I didn't know if I need to go through the court team or if I can do that
Yeah.
here.
I would prefer that he files the motion first, and then
Okay.
we set it.
I understand that. I mean, usually I like to have the motions filed before they're set, but I just want to know if it's just waiting on something and it's already drafted. But just, Mr. Cobb, if you could file the motion and then get it set for a hearing, kind of figure out between the two of you how much time you think it's going to take. That way we know we don't put it on a date that has a bunch of other lengthy hearings and we end up in a situation where you guys are stuck here for hours.
Yes,
Your
sir.
Honor, in order to expedite the time, I wouldn't mind reviewing this motion, and maybe we could reach an agreement if I see validity to it, and I don't object.
I'll email it to her today.
Can we make your agreement today? I've been 16 months
I know you have, that's part of the issue, but
on illegal arrest.
Okay, well, I don't know that, Mr. Russell, obviously, a motion's going to be filed. I haven't seen it yet. The state hasn't seen it yet. So let's get it filed. I mean, today's a pretrial conference date. We've got, over 100 inmates we're going to be handling today. So today's not the day to have motions heard, but certainly we can find y'all a date sooner than later, once we have a motion filed.
and I'll send that over to the state today.
Please, thank you.
All right.
So we'll put it on the June 24th day at 9 o'clock, but let's try to have that motion heard before that.
Right, and then if the state and I can reach some type of plea agreement, I'll advance it on the docket. Judge, State of Florida versus Lonnie Strahan. He has two cases on the docket, 2021 CF 1400, 21 CF 1403. I believe last time we talked, the state and I were going to try the 2021 CF 1400 case. And so I'd like to leave it on the docket for Monday. And then I'm going to talk to the state in between and get everything together and see what we need to do to get ready to try.
Okay, so that's 21 CF 1400. And then the other one will just kind of ride along with it. And
As far as remaining on the docket for control purposes, yes.
Judge, your jury selection dates following Monday, what are those dates? What is
it's
it?
going to be the 12th and the 19th.
Thank you.
But obviously, we'll see kind of what things look like after today. But then again, I think we had 24 set after pretrial last time and ended up with 0. I just don't know how it's going to pan out. We'll talk about that more on Monday, the 5th, to see kind of where we're at. And then ultimately, then the jury review date on the 9th will kind of give us a better idea on which trials are going to go which weeks.
The 5th, 9th, 12th, 19th. Okay.
So
All right, thank you.
next Friday, the next 3 Mondays,
Yes, sir.
and next Friday as well. So, all right, Mr. Strahan, we'll see you back on Monday.
Judge, I believe those are the cases I have on the docket. Can I be excused?
Yes, sir.
Thank you,
Mr.
Judge.
Cobb. Mr. Ramey? Okay, I'll pass you. All right, Ms. Dudley? You have Durham? You're, okay.
Yeah, I'm coming from Ricky Durham on Delroy Durham in 24 CF 2412, 1419, and 1417. It's my understanding he was recently retained, so we'd ask for a continuance to the next pretrial.
Yeah, I think there was a Feretta hearing that I granted, and then he hired Mr. Durham, so it's his first time up.
Yes, sir.
Yes, no objection, Your Honor.
Any objections to that, Mr. Durham?
No, sir.
All right, 6/24 at 9 o'clock.
Now, the first one I have is Matthew Bachman. This is Matthew Bachman in 21 CF 2261 and 23 CF 2528. We previously discussed these cases. These are older cases, but not as old for me. We are getting those depots set based on some stuff that we need to get from the officers in this case. We have seen how much time we need. We're just working on trying to find a date to get everything done. So we ask for a continuance to the next cycle. I have discussed that with Mr. Bachman at the jail.
And who's on the case, Ms.
No objection, Your Honor.
I know what we talked about last time, but these cases are obviously
Yes,
getting
sir.
pretty old. They're new for you, Ms. Dudley, but They're some of the oldest we've got. So,
Yes, sir.
June 24th, I'd like it to be ready for a resolution, whether that's going to be a trial or
Yes,
a
sir.
plea or whatever by that point, but we're just getting very old with these
Yes, sir.
cases.
I'll do my best to get it there.
All right. Thank you, Mr. Bachman.
And the next I have is Justin Diaz. It is 21 CF 2951, 24 CF 1499. I am still in need of discovery in his case. I would ask for continuance to the next cycle. I came on the case later, but I do need discovery in his case. so we
Which
can try
case
to-
are you waiting for discovery?
In both.
Oh. How long have you been on these?
I've been on, I think this is the third cycle, I believe.
Why hasn't discovery been done? I know Mr. Diaz was over in Walton County for a while, but this case can still move. Has discovery been sent over?
Your Honor, I'm checking the records.
This actually might be second cycle. Sure. Second cycle, yeah. Second cycle, Your Honor, my apologies.
You haven't received anything at all, Ms. Dudley?
No, because I'm the second attorney on it, so I haven't received anything.
What I'm saying, have you asked directly?
Yeah. And I also sent another email, in that group of email with the deposition.
Your Honor, the only thing I can say, I cannot check right now. We had that change in the assistants in my office. The assistant that used to be from the beginning on this case was removed from the case, and there is another one, so we're trying to figure that out and straighten it out. I'll send the discovery today to you.
All right,
Let's
thank
just
you.
make sure it gets done, because, I mean, one of these cases is ancient, and discovery needs to be sent over. I'm sure it's all put together, it just needs to be resent to the new lawyer.
Yes,
I
sir.
think I asked that question last time we were here, just, how are y'all doing that? Are y'all expecting it to go from defense lawyer to a defense lawyer? And everything I was told is, no, we just send them a link and they get everything new. So, I mean, it literally should take about 30 seconds to get that done. And I know everyone's got a lot of cases, but, when cases are 3 to 4 years old, discovery shouldn't be a problem at this point.
Yes, sir.
So I don't expect I'm going to try continue the 21 case again. So
Yes, sir.
624.
Your Honor, this is Destiny Jackson, 24 CF 852, 24 CF 1681. We have did some depositions last week. We are missing cell phone downloads. I need to do a motion to unseal the search warrant based on those depots, and I need to get transcripts, so I would ask for a continuance based on that.
No objection.
The cell phone downloads and potentially unseal the search warrant. Ms. Dudley? You said unseal the search
Yes,
warrant
sir.
as well as the cell phone.
Based on depositions, there were no CIs, no control buys. So we're going to do a motion to unseal that.
So that'll
And
be-
I'll get that filed within next week.
All right, 624 at 9 o'clock.
Yes, sir.
We'll see you back on that day, Ms. Jackson.
And our next have is Terrence McLean in 24 CF 2829, 21 CF 1192, 21 CF 1484, 21 CF 2777. We can leave him set for docket day for a plea.
Is that to all of his cases?
Yes, sir.
All right, Mr. McLean, we'll see you back on Monday, May 5th at 9 o'clock for purposes of a plea. Did we skip Hart?
Hart is not incarcerated. We can deal with him real quick, Your Honor. Kobe Hart,
Did he get out since? Is that?
Yes, yes,
is
sir.
he here?
he's not there as a waiver on file.
Okay, we'll address him later.
Okay,
Let's keep
that's
going
fine.
with him.
Yes, sir.
I just want to make sure I didn't miss something.
Yes, sir. No, he did bond out.
All right, perfect.
Your Honor, this is Gil McGee, 24 CF 376 and 24 CF 669. We have a deposition set on June 4th. They're trying to finish these cases out. I would ask for continuance to the next pretrial. There are some witnesses that didn't show that I really do need based on, it goes to credibility of the victim in this case.
I understand. Well, you need them, then you have to have the depositions, and they have to show up for them as well.
Yes,
Were
sir.
they served for depositions previously?
One was, one wasn't, so I'm still working on trying to get the other one.
24th at 9 o'clock. Mr. McGee, we've got some depositions coming up and before that, so we'll see how things work out. Thank you.
Next is Russell McGlaclin in 24 CF 1304 and 24 CF 2090. We are waiting on discovery. The state has told me they're going to send that. I recently was retained since last cycle. However, if we can leave this for docket day because of his health issues, I want to see if I can get it worked out.
Okay.
If I can leave it.
Issues with that, Mr.
And we're tracking discovery. I've already put in the request, Your Honor.
Yeah, it looks like you just got on the case last month, but, well, it's almost 2 months ago now, but let's just make sure these discovery requests are getting done quickly.
I'm hoping, based on his health stuff, I can try to get it worked out since it's just possession charges. So I would like to leave them set to see if we can try to get that done.
You want to put down for plea or continue?
Yes, sir.
All right, plea continue from Mr. McLaughlin. He'll be back on Monday, May 5th.
Your Honor, this is Jennifer Odman, 24 CF 378 and 24 CF 120. We've tried to negotiate this. There's some more information we need. I need to depose a witness who did not show up for depots, and depose another witness. I would ask for one more continuance on her.
Is the no-show subpoenaed or served with the subpoena?
Yes.
Okay, well, let's get it done, otherwise.
Yes, sir.
Handle with an order to show cause. People need
Yes,
to
sir.
show up when they're subpoenaed, otherwise they're violating a court order.
Yes, sir.
All right, any objections,
No,
Ms.
no
Simmons?
objection.
All right, these cases are, approaching pretty old as well, so let's see what we can do to expedite that deposition. All right, June 24th, 9 o'clock, Ms. Odom.
Your Honor, next is Amon Robinson in 23 CF 812 and 24 CF 638. And I was also recently retained in 24 CF 1682.
Mr. Williams, are you on the
Yeah, Your Honor,
1682
you
case?
appointed me on the 1682 case. Ms. Dudley just recently did a notice of appearance in that case, so she's handling all three of these cases.
Okay, so I'll relieve you from, at this time.
She's going to file a substitution of counsel, so we'll
Okay.
Yes, sir.
All right,
Thank
thank
you,
you, Mr. Williams.
Your Honor, we have a depot set on two of the cases on June 4th on the 1682 case. That's the one I need to do a motion on seal search warrant, get cell phone downloads, based on the depositions. I would ask for continuance to the next cycle.
No objection, Your Honor.
All right, Mr. Robinson, we'll see you back on June 24th. Obviously, if there's a motion hearing before that, we'll see you sooner.
Okay.
Otherwise, June 24th at 9 o'clock.
The next one I have is Jeffrey Todd Wagner, 24 CF 121, 24 CF 122, and 20 CF 380. Your Honor, this is the one we needed to depose that officer who didn't show, but what happened was the previous prosecutor left right after that court date. We talked about that. So I've spoken with the new prosecutor. We're going to get that scheduled so we can get these cases resolved. So I'll just ask for one last continuance on it. I think we're close. I've talked to him about some of the other cases that I believe will go away, but obviously he doesn't know everything about the cases that I've.
The newest case is 15 months old.
Yeah. So that was the one we had the officer, and then I thought we had it close to being worked out, but obviously it's changing prosecution.
Okay. Whose case is it now? It's mine, Your Honor. Okay. This is an absolutely last continuance.
Yes, sir.
And if it's a situation where someone's not appearing or whatever it is, then.
We'll do a
what
motion,
you
Your
need
Honor.
to
Yes,
do.
sir.
Again, I feel like I'm preaching up here sometimes about orders to show cause and
Yes, sir.
motions to compel. Y'all are working hard to get these cases done. If people don't want to cooperate, then we have to make sure that that's being done.
Yes, sir.
All right.
All right, I'll come see. And the last one I have is Kobe Hart. That's in 24 CF 1881 and 24 CF 1972. We'll work on get deposition dates on this one, so we can get these resolved. I believe once we do depositions based on the victim drop charge and the witness statements that I've seen in the case, we can get this case resolved once I can get those depots done.
All right, who's got, all right.
I guess we'll put him on the 22nd or 23rd. It's 23rd.
Get some progress on these cases. I mean, this one's not terribly old, but it's from August and we're still talking about setting depositions.
I haven't had it that long, but I do understand the court's position.
Well, and I say this, especially to the private bar, when you take a case, you kind of take it where it is.
I understand.
And, I seem to be getting a lot of, motions to redo depositions and stuff like that lately. You haven't done that, Ms. Dudley, so I'm not calling you out for that. And which is allowed to do, but I think you know that I've done that job for quite some time, and there are cases I turned away just because I didn't want to deal with how much of a mess it already was.
Absolutely. I'm very leery of taking
Because I knew the judge was
cases.
going to force me to go to trial too soon, so.
I agree. I'm very leery of taking cases that depots have already been done.
Okay,
So.
thank you, Ms. Dudley, that's June 24th. Well, I guess we'll do, because he's out now.
Yes, sir.
June 23rd at 9 o'clock.
Yes, sir. I believe that's all I have.
All right, thank you, Ms. Dudley.
Oh, no, I do have one more. Sorry. Robert Jones is under the PD. He's like close to the end of the jail list.
Okay,
I was retained on that in 24 CF 2083 and 24 CF 2735. I would ask for a continuance. I was retained yesterday.
is it Zakis?
Yes.
Okay.
Yes, Your Honor.
Judge, I'll move to,
You have been retained and filed your notice?
Yes.
Okay.
So I told them I would announce that so they didn't have to try to bring them later on today.
All right, and you're asking us to continue that to June 24th?
Yes, sir.
At 9 o'clock.
Yes, sir.
All right, give me the order.
Judge,
Yes, sir.
PD withdraw, moves
Yes.
to withdraw.
Thank you, Madam Clerk. Thank you, Your Honor.
She keeps us straight. All right, Mr. Charles Williams?
Yes, Your Honor.
Morning.
I think first we're calling State of Florida versus Jack Barr. That's two case numbers, Your Honor, 23 CF 1016 and 22 CF 1851. I was appointed to Mr. Barr in February, Your Honor.
Mr.
and,
Williams, give me 1 second to get there.
Certainly, I'm
I'm
sorry.
sorry, it just. All right, go ahead, Mr. Barr.
So after reviewing the discovery, I felt the need for an investigator. I filed that motion. I believe it's pending with you.
Is that on for one particular case, or?
Well, it is on this case.
Which
Oh, you
cases?
mean
He's
of his
got
two
three cases
cases?
on the docket.
Yes, the
One's a VOP, I understand, but.
conspiracy, the solicitation case. I'm not sure which number that is, Your Honor, I'm sorry. I think it's 1016. Pretty sure it is, it's 23 case.
All right, the order is signed. Mr. Williams,
I'm sorry, Your Honor?
the order is signed.
Okay, great, Your Honor. I guess we could continue it to the next cycle, I think it's in June.
June 24th.
16. And hopefully by then we'll have more to report. I don't really anticipate depositions or anything in this case.
Yeah, you will. You'll have to have one.
But
Okay.
we have to talk about that.
All right, we'll see you back on June 24th at 9 o'clock. Thank you, Mr.
See you then.
All right.
And next, Your Honor, I believe we're calling out State of Florida versus Timothy Cochran, who's about to join me here.
That's the same, this order's being signed.
I'm sorry, Your Honor?
The order's been signed.
That one as well? Okay. So I guess we'd request that same date, the June 24th, Your Honor?
June 24th at 9 o'clock for Mr. Cochran. So you'll be back on that date.
I believe we have Mr. Valley next. Is that correct, Mr. Baylor? Yeah. Your Honor, this is one you appointed me to about, the end of March, March 31st. And again, same situation. I've reviewed,
I think I've got that one.
it hadn't been signed as of yesterday. Or I should say it hadn't been put on the case docket. I didn't have a case.
What I'm saying is I don't see it. I don't think that,
You don't see the motion?
I don't see the motion. Let me see if it's.
I'll double check that, make sure we get it to your assistant then.
Let me double check a different way.
Mm-hmm.
And that's one of the issues with sometimes sending things through the portal or whatever, they end up in a different
Yeah.
place or,
I think that's what happened. My assistant sent them to the portal, which we do in other counties, and found out that you'd rather have them sent directly to your
well, the
office.
reason I prefer it is because they always get to me when they go through email, and so.
Gotcha.
I want to make sure that it's.
And I think we've corrected that, at least we've got a little star by your name for these kind of
I'm
motions.
not sure I deserve a star for it, but.
Well, I'll call it an asterisk then.
All right, it looks like it went through the portal. See, if it goes through the portal and it can end up in the file, but not in a situation where I can see it, and since it's hard to check, I have over 800 criminal cases assigned to me, so I can't just check them all. So, but it is in the actual folder. I see it now. It just came through on Friday.
So I assume we could do this June 24th date again, Your Honor?
It's June 24th at 9 o'clock. When was the motion filed? I think that
I
was.
believe it was on the 18th, Your Honor.
I don't see the motion. That's probably one of the issues, because, sometimes you'll get a response back from my office that we need to see the motion first, especially on this particular type of thing, because I got to see, as you've done on the other two, you attach the email from JAC saying we don't have an opinion on this. And until I see that, I can't sign it without that. So I don't see the motion, but if you'll go ahead and forward that to me, I'll get it signed,
Yes, Your Honor.
because I don't see it in the court system yet. The last thing filed was the amended order to appoint counsel from the 15th.
Very well.
So it may be somewhere, again, that's,
I'll
I'm
make
not
sure.
trying to degrade the portal here or anything, but
gotcha.
sometimes things just don't make it through.
I'll make sure we get that to your assistant today.
Okay.
And then lastly, Your Honor, I have Mr. Whittington. Yeah. Okay, great.
We'll recall him. Okay.
In the meantime, Ms. Leone and I would like to approach him.
Sure.
He's here already.
Okay.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Bryan Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then
All right, Mr. Whittington, sounds like we're going to come back on Monday at 9 o'clock. Your lawyer's going to come talk to you again before then about potential resolution to these things and some other matters. So we'll see you on Monday, the 5th. But I'm going to call it plea or trial at this point, right? Sure. Because I think I said last continuance last time, this case is over a year old. I know it's extensive, but I really think it needs to be brought in for a landing given the situation.
There you go. I'll be out to see you, okay?
All right, we'll see you back on Monday.
And Your Honor, that concludes my cases, so could I be excused?
You have, that's everything, yes.
I think.
All right, thank you, Mr. Williams.
Thank you, Your Honor.
All right, Mr. Harsher.
Your Honor, the case that I'm here covering for, I believe, is consolidated with Mr. Ramey's case, so wait until he's ready to be called.
Okay, and I think Mr. Riasti's on that case too?
Maybe so, Judge.
Because I think there's 3 different cases with 3 different lawyers.
Sounds correct.
Okay. And I know my office received something that he may be in Pensacola first this morning. In fact, we'll talk about that when he gets here.
Yes, Your
About the email I received yesterday. All right. Ms. Jaquit, are you ready for yours?
I have a few, Your Honor, that I'm going to pull out and handle, and then Mr. Kleins will handle the rest.
Let's just somewhat stick to our list as best we can.
Yes.
Because,
We can tag team it and back and forth if you'd like.
well, it's really about who's lining up in the jail. If we keep skipping around the docket.
You want? Do you have any? If you have anybody, we can. Okay, I was gonna say I can move and tuck and weave.
I think the only person else I have on the list is Mr. Switek. Do you want me to try and, well, I'm not sure what
Are you ready, Mr.
he's
Switek?
got.
I'll step back.
Is there any chance you could get up? Who do you have, Mr. Switek? Do you have more than one?
Pierce, who's not on Ms. Basso's docket.
I see him on the bill list, Judge, but I don't know that we saw him on the docket I was looking at. But I know he is. I have it.
So just the one, that way we can get Mr. Switek moving, and then RCC will kind of take over.
I also have Mr. Lopez to talk to you about.
We can talk, but that was set for Monday. I mean, if y'all want to talk about it, we certainly can, but the trial.
Yeah, we put a motion in for a witness to appear by Zoom.
Yes, I did want to talk to you about that. And just as far as what's the reason that they needed to appear by Zoom?
She lives in South Carolina.
Okay, and as far, do we think it's going to be extensive testimony?
Should be no more than a half hour.
Okay, See, that's the kind of simple stuff I'd like to know. That way I can say, yeah, it's going to be fine. If it turns out it's going to be 4 hours of testimony, it makes it a little bit different, but.
You think half
There
hour?
may be a motion associated with that particular witness as far as whether or not she can testify at all. But Zoom would be appropriate, given the length of time and the nature of the expected testimony. If the court does not object, the state's not going to object.
Well, here's the thing, is we're at pretrial. We talked about trial back in February. We talked about specific dates, which I know we've coordinated as being the second week of the trial week, so you can get everything together. But if there's pending motions, or I guess pending potential motions, we need to get them filed so we can get them heard, because we're running out of dates before we could potentially get anything heard. I don't have an issue, and that's why I want to just bring it up. I've read the motion as far as the video testimony. I'm fine with that. I just wanted to kind of speak with you quickly to make sure it wasn't going to be, half the trial was going to be someone from Zoom.
All right, if we've got trouble scheduling the motion for the state, I mean, I'm on the cusp of having to ask for continuance on it, and I don't want to do it, because we've got everybody primed to go on the 19th.
It would only be a relevancy issue, Judge. That's normally something we can even address at court. So.
All right, well, see if y'all can talk about it, and if it's something we can hear, I guess no later than Friday next week, at the jury review date. I just don't like the idea of having motions being heard before trial. I know sometimes that's done, but there's too many times I see it where that is some sort of dispositive potential issue, and it goes one way and the trial goes away, and then we just had, especially in certain types of cases, 50 or 60 members of the community come in for jury duty where they didn't have to. So I'm really trying to avoid that if I can. So let's put it on for Monday, the 5th, for docket day.
Veronica, Mr. Lopez appear for docket day by Zoom. He's in California.
That would be fine, but he'll have to be here on Friday if we're going to trial.
He'll have to be here on the 5th.
I think just to go over things like what is there an offer? Has it been conveyed? Typical stuff. Make sure he understands. What his possible penalties are. Well, we talked about the second week.
19th. It'd just be, I don't know how much good it would do to have him here on Friday.
Yeah, I understand. I'm thinking out loud a little bit as well, Mr. Switek. You're not leading me there fast enough. So, but I understand to not be coming here for a Friday, sit around for a week before trial. So, does the state have any objection to him appearing by Zoom until the actual trial date?
Your Honor, we do believe that'll protect his rights, so if it's acceptable to the court, we're not going to object to that.
All right, I'm fine with that, but obviously we'll have to talk about those things. I would prefer to do that on the Friday date as opposed to Monday, because just Monday's a bigger docket, so we'll talk about that on Friday.
Understood.
All right. And then this is Mr. Pierce?
This is Jared Pierce in 2018 CF 2647, 24 CF 1948, 24 CF 2549, and 25 CF 647.
All right, what do we do with Mr. Pierce today?
Oh, we're waiting for a universal offer from the state on this. These.
Who has the case for the state?
I do, Judge.
Okay.
He also has a VOP, and he managed to get a law violation while the other new one was pending on his devices.
Okay,
So
so
I'm just trying to make sure I have everything that we know of.
do we think we'll have this for Monday?
I can get that to Mr. Switek by probably, I would say, no later than Friday, but I'll try by tomorrow.
Switek, you want to keep it for Monday?
The 5th?
Yes.
That'd be fine, Judge.
That would be everything, correct, Mr. Switek?
Yes, ma'am.
VOP as well? Okay, we'll keep them all together.
All right, I'm putting it on for 5-5 for a possible plea. All right, thank you, Mr. Pierce, thank you, Mr. Switek.
Thank you, Your Honor.
All right, Mr. Jaquith, Mr. Kleins, however y'all want to go through it.
Your Honor, Mr. Hendricks is before the court in several cases. Has the court received a copy of the report from Dr. McDonald? Hang on one second, Mr. Hendricks. I do have a copy if the court has not received
I
one.
looked at it yesterday, but I looked at several of them yesterday, so I just want to get to my notes on it. Problem is y'all have cases under 3 different names.
I know, I apologize. We're
No,
gonna
it's
fix that
fine.
after, we were just trying to cut down on the amount of paperwork we were sending you guys, so we're working on getting that resolved.
You know what page it's on?
What page the recommendations on? Oh, I'm sorry, I have him on page 28.
All right, here he is. All right. And I have, like I said, I did look over the evaluation report that was done previously. I read that yesterday.
And Your Honor, I believe the state is in a position to stipulate to that report. And so, in which case, I'm sorry, I'll let Mr. Sheik speak first.
That's correct, yes.
And based on that, Your Honor, I do have an order for the court. May I approach? Hospital to get competency training.
I don't understand how that's possible when I told them, I mean, I'm extremely intelligent. I told them everything that's going on. They said they offered me a 6-month time served, but just because I say that I don't agree with the charges, and I stated it in both cases, they offered me, they said I was competent enough to take a 3-year probation sentence and a 6-month felony charge for defending myself against a sex offender that said he would stab my eye out. But when I said, can I get no contest adjudication withheld, now I'm incompetent?
All I can say
Supposedly?
There's not been an offer made in this case at this time due to the competency issue. There's also a pending misdemeanor stalking charge that needs to be resolved as well, so I'm not sure if he's referring to something that maybe had something to do with that.
Let her finish.
However, Your Honor, obviously, given the report and given my conversations with the jail mental health stuff as well, which confirmed essentially what Dr. McDonald put in her report, I would not be comfortable assisting Mr. Hendricks in entering a plea at this point.
Bear with me, because I have 2 WL numbers. The Supreme Court Justice actually dismissed my cases already. It's a WL 422, I believe it's 9076, and that's because with the stalking charge, it's not even stalking. What happened was
Hold on, Mr. Hendricks. Don't talk about the facts of any case.
Gas station security.
Don't talk about the facts of any case.
Family.
Judge, I would just ask that the court have
Lofts
Mr.
and
Hendricks
Jeffrey
removed
Wieners, where
before
she's-
he makes a statement that could potentially
All
be
right, Mr.
incriminating.
Hendricks, we're going to have you go
she's
back.
from
Mr.
Lofts,
Hendricks, up
Jeffrey
here.
Wieners, and they
Mr.
say they're gonna
Hendricks.
rape my family over phone calls, saying they're the best in 40 business.
All right, let's take them
Best in
back.
the business for 40 years. I don't understand how this works. You keep sending them in from there?
Sorry, Judge.
You know or something for the crimes against me?
All right, based on the stipulation and the report that I've read, I am going to find that Mr. Hendricks is not competent to proceed. I've signed the order for the Florida State Hospital, and then we'll bring him back once we get an updated report.
Thank you, Your Honor. Hey, Mr. Kemp.
Just for the record, I also reviewed the recording from last court date where there were similar outbursts, so.
Your Honor, this is Casey Kemp before the court, 24 CF 1332. Your Honor, Mr. Kemp also had a competency report that the court received where he was determined to be competent. I do have a written order just declaring him competent so that we can proceed and making sure the record's clear, if I may approach with that.
Yes. And that's why I said I have to review which one it was, because I read all of them yesterday, and I didn't want to confuse any of
I
them.
think the other two should be much smoother, Judge. Hey, Gary, come around here. Plea agreement here.
All right, so based on the order finding him competent to proceed, I'm assuming obviously everyone stipulated to the report.
Yes. May I pause for just one moment?
Go ahead. Sorry. Normally the state doesn't contest competence, so. But I just want to put it on the record.
Thank you, Your Honor. I apologize. Mr. Judge is going to ask you if you still have questions, so I want to make sure they're all answered. Okay, Judge, Mr. Kemp is present in 24 CF 13832. The court having found him competent to proceed, we are going to be entering a no contest plea today as charged. It will be a downward departure based on a legitimate uncoerced plea bargain. It will be an adjudication of guilt, 2 years of community control. There are $867 in court costs and a $150 cost of defense. He will need to enter and successfully complete the Phoenix House inpatient program, continue the aftercare once released from the program through termination of supervision, and he's not to have any controlled substances without a prescription, random urinalysis, and no contact with Floyd Kemp. And, Your Honor, there's no objection to the score sheet,
So it's
like,
a relative is the alleged victim?
it
It's
is.
his father.
It's his father.
And you talked to him, Ms. Leone, or someone from your
Oh,
office?
yeah. We discussed this at length, and he is in agreement with the plea agreement.
I can
I know
tell
you
you,
would
I
have
also,
offered that, I just figured I'd ask the question.
I also spoke with him, and those were his wishes to me as well, so I can confirm, Ms. Leone. May I approach?
I don't need three people to confirm it, I just want to make sure it's clear that it's been talked about.
The more the better.
All right, Mr. Kemp, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
You have to say yes or no.
You have to say it out loud.
Yes, sir.
Okay. Can you state your full name and date of birth, please?
Casey Kemp.
All right. Date of birth?
August 30th, 1979.
Okay. And Mr. Kemp, you're here in 2024 CF 1332, charged with battery on a person above the age of 65. I've been handing a plea and sentencing agreement that calls for, as your attorney just announced, an adjudication of guilt, which would make you a convicted felon, and 2 years of community control, enter and successfully complete Phoenix House, also the aftercare once released from the program. It's my understanding Phoenix Houses can be 18 months or more?
Correct, Your Honor.
Or
That
is it even like a minimum, maybe?
There's no minimum, but I've not seen, most people don't complete before the 18-month mark, so, but some people do stay longer. I've explained all that to Mr. Kemp as well.
I just know it's a very long and intense program that the vast majority of people who come back from it don't come back to the court, so which is a good thing, Mr. Kemp. No controlled substances without a prescription, random urinalysis, no contact with your dad. Is that the agreement that you want to do?
Yeah, and you said you was waiving something, right?
Oh, we were going to ask to waive the cost of supervision
Waive
since.
cost of supervision, we'll get to that, sure.
He'd like the court to authorize community service work for eligible costs as well.
No objection.
Okay. All right, Mr. Kemp, did you go over this plea and sentencing agreement with your attorney?
Yes.
All right, you have to say it out loud. I can see that you're nodding, Mr. Kemp, but I need everything recorded
Yes, sir.
audibly for the record. All right, did you understand the agreement?
Yes, sir.
Do you have any other questions about it?
No, sir.
Okay, did you sign the agreement?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
You understand the question?
Yes.
All right,
He wants to know
are
if
you
he's-
happy with the work the lawyers have done for you?
Oh, yeah, they do great.
Okay, thank you. Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
Not many of them.
Well, okay.
No, sir.
I'll kind of put it out, now's not the time to joke.
Uh,
Okay, this is a pretty serious thing where you're pleading to a felony and being put in community control, and I know sometimes people, when they get nervous, sometimes make jokes. I'm one of those people. But what I want to make sure is that you understand this. So are you suffering from any mental health issues that you need treatment for? Or are any of those issues causing you to not understand what's going on here today? Okay, and obviously, we just got a report saying that you're ready to go as far as competence, so I just want to make sure if there's anything that you have concerns about, that you're making a good decision here for yourself. Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea? Because everyone needs an occupancy. Has anyone promised you anything other than the terms of this agreement? All right. Do you understand that by entering this agreement and entering a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 2 of the agreement that you signed? You understand all that?
Yes, sir.
Okay. And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. Do you have any other questions before I accept your plea? All right. Is this the state's agreement?
It is, Your Honor.
All right. And it's a downward departure based on that plea bargain, correct?
Yes, Your Honor.
All right. Because otherwise, Mr. Kemp, you scored 40 months in state prison, 40.5 months to be exact, which means if you don't do everything you're supposed to on community control and you come back, that number one, that number goes up. But two, there's a good chance you could get that number. Do you understand that? Do you
Yeah, that's
understand
why I was
if you
trying to-
violate your community control, if you don't finish the Phoenix house?
Yes, sir.
All
That's
those
why I
things,
was-
you could end up in prison for 3.5 years or so.
Yeah, that's why I was trying to get the CC took off of there. To make sure I complete the program.
The state, I've addressed it with the state. The state is unwilling. So the offer is either to accept this if he wants to do Phoenix House. So he understands. We went over that extensively, Judge.
Okay, thank you. All right, any other questions, Mr. Kemp?
Do you have any other
No,
questions?
that's it.
All right, and what is your plea? Are you pleading guilty, not guilty, or no contest?
Contest.
Okay. I'm going to accept your no contest as freely, voluntarily, knowingly given. Adjudicate you guilty, 2 years community control, $867 in court costs, $150 cost of defense. I'm going to allow you to do community service for what you're able to pay off those costs. Successfully complete the Phoenix House inpatient program, continue aftercare once you're released from that program. And you have to do that throughout the termination of your community control. No controlled substances without a prescription, random urinalysis for the detection of such substances that you're not supposed to be in possession or use, and then no contact with your dad. Okay.
Now,
And anything that I've missed? Waive cost of supervision.
the fine, how much was the fine?
There's no fine, it's
There's no
court
fine.
costs,
It's the court costs.
$867, and I've allowed you to do community service for that.
Oh,
purpose.
okay.
It's in the copy of the plea agreement I gave you has those numbers on it.
I thought it was 5,000.
No, that's just the maximum.
That's
that
the
you can get.
maximum, yeah. No, it's 867 and 150.
Technically, you haven't been fined anything, these are just court costs.
Thank you.
All right, thank you, Mr. Kemp. I need you to be fingerprinted. You want him to meet with probation first?
Either way.
Probation first? Then you have to be fingerprinted, Mr. Kemp.
And Your Honor, can I get Mr. Kemp's first name?
Casey,
Casey with a K.
The
K-A-C-E-Y.
daddy.
Oh, Floyd.
Floyd.
F-L-O-Y-D.
I thought I said it a couple of times, but
And that'll be Bart's to bed.
yes, bars to bed. And I don't think I finished saying this. Mr. Kemp, you have 30 days to appeal the judgment and sentence. You have 30 days to appeal if you want to appeal any issues regarding your case.
Your Honor, this is Anthony King before the court. Those case numbers are 23 CF 2708 and 23 CF 2723. We have a competency report. Did the court get a copy of that one as well?
Again, I'm sorry. Do you know what page he's on? Again, I think.
He is on page 29, Your Honor.
Okay, I didn't see the report. I saw, it looked like there might have been one done, but I didn't get a copy of it yet.
I have a copy of the report if I may approach. And this is literally the court copy. He has been found competent to proceed, Your Honor.
Any, are y'all stipulating for me making the decision on competency regarding the report?
Yes, and Your Honor, Ms. Barrickman indicated she doesn't have an objection to that report. That's correct.
Okay. Let me just go through it. All right, based on my review of Dr. McDonald's report, I'll find that he's competent, and I'll sign that order right now.
Thank you, Your Honor.
All right, and what do we want to do with Mr. King?
Your Honor, my review of this case does not look like depots were done. So Mr. Kleins is asking that we continue the case so that he can review the discovery and review it with Mr. King and then also set depositions.
Has he previously been found incompetent? I mean, the case is very old.
Yeah, I do not believe so, Your Honor.
Competency was raised, I believe, by Ms. Flowers.
It
early
was.
This year, and so she had asked for the competency report. And just for your information, some depositions have been completed, but not all. There's just 2 different case numbers.
Okay, I'll reach out to you and see if we can get copies of those depositions because it doesn't look like they ever made it into our.
I'm trying to ask that because I know Ms. Jaquit and Mr. Kleins, you're taking over this case brand new. So I just want to kind of see where things have gone and what we need to finish. So
Can we just approach briefly,
Sure.
Judge?
I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, so where do we want to set Mr. King to the 24th?
I would ask to set it for the 24th, Your Honor. If there's any motion practice that needs to be done, Mr. Kleins can get that set back on an earlier docket to get that resolved.
All right, June 24th at 9 o'clock. We'll see you back on that day, Mr. King. Obviously, Mr. Kleins has taken over your case now, and he's going to come out and see you. If there's anything that needs to be done ahead of time, we'll certainly get those done on the days that are available. All right, thank you, Mr. King.
I'll see you.
I'll step back and let you do them, and then when I'll.
Your Honor, this is Mr. James Felen. He's got a number of cases. I met with him at the jail yesterday. We're going to be asking the court for a one-cycle continuance.
Is that going to be under you?
Yeah, there will be notices of appearance filed on all of these cases.
Okay, I just
for
want to
me.
get to the right page then.
I see this is on page 26.
There
And
it
it is under Mr. Kleins.
is. Just all your cases are under 3 different names, and I know that will fix itself over the next
Yes, sir.
cycle or so, but obviously, I think with the PD, we had a somewhat similar issue, so it's kind of hard to keep track of where to find them. So go
We'll
ahead,
get
Mr. Kleins.
cleared up by the end of the week. I did meet with Mr. Felen yesterday. I'm going to ask the court for a continuance. I will process the depositions that need to take place probably by the end of the week. So hopefully, we'll have those set, and I'll be moving these cases as fast as I can.
I know the most recent case is not terribly old, but, there's the 3 VOPs, so we got to make sure we're on top of those. June 24th, 9 o'clock. We'll see you back on that.
For the record, I just wanted to state the offer. Defendant scores 144.6 points, month. So that would be the state's offer at this time for all cases, including the VOPs.
I appreciate that.
Thank you, Mr. Phelan.
Judges Tavares Allen before the court. He has two cases. One's on page 28. Somehow the other one ended up under my name, so it's on page 32. The one we had submitted the court a written plea agreement, it just didn't make it to the clerk's office, so I'm going to resubmit that plea agreement. However, Mr. Allen has also reached an agreement on the 386 case number, and that calls for him to plead no contest as charged. I'm sorry, do you want me to?
No, I'm just making, when you said which case number, I was just trying to make sure which one that was, as I'm flipping back and forth. Go ahead.
He'll be pleading no contest as charged. To be an adjudication of guilt, 2 years of probation on each count to run concurrently, $867 in court costs, a $100 cost of defense, an anger management course, and no contact with either victim. And I will provide those names to you, Mr. Berry, because I handwrote this, so I don't have those names and correct spelling. So I will email you those if that's okay. Mr. Allen will reside in Fort Walton Beach, so just for probation's information, he will be a transfer down south. And Your Honor, the 281 case number, does have an order on it, but I'm going to announce just so we can make sure they get resolved. That's going to be a plea to a lesser included disorderly, 877.03, adjudicate time served, $270 in court costs, and $100 cost of defense. That is to include the $50 cost of defense for misdemeanor and the $50 application fee. That's why it's $100 on that one. And he will need to pay those financials within 90 days. And Your Honor, we have no objection to the amended score sheet now that the charges have been altered, and we will, does the court have any questions? Sorry.
So a written plea is going to be filed?
I have it right. I have a written plea agreement for you, but this is the one where I brought the plea agreement Monday and it didn't get signed, and then I added the extra case number onto this one.
Okay, perfect.
So I just wanted to make sure the court was aware of that. That's why it's dated from Monday.
All right.
Yeah.
Mr. Allen, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do, sir.
All right. Can you give me your full name and date of birth?
Tavares Allen, 7/22/75.
Okay. And Mr. Allen, you're here on two different cases. You've got 25 CF 281, where you're currently charged with battery on an inmate, and you've got 25 CF 386, where you're charged with 2 counts of felony battery. Do you understand those charges?
Sir.
All right. I've been handed a plea and sentencing agreement that calls for you to, on the 281 case, plead to the lesser included offense of disorderly conduct. Be time served, $270 in court costs, $100 cost of defense, and pay those within 90 days of your release.
Sir.
And then in the other case, 25 CF 386, it's as charged to the 2 counts of felony battery, which are each punishable up to 5 years in state prison and a $5,000 fine. For both cases, it's adjudication of guilt, 2 years probation, $867 court costs, $100 cost of defense, anger management, and no contact with the victims in those cases. Do you understand that?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go over this agreement and sign it with your lawyer? Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Are you currently suffering from any mental health issues?
Are you suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than these terms? No. Okay. Do you understand that by entering a plea to each of these charges, there won't be any trial of any kind, and you're giving up your trial rights, which are on page 2 of that agreement that you signed? You understand all that?
Sir.
Sorry, I know sometimes I speak pretty fast in
okay.
long sentences, so I just want to make sure.
Got used to it.
I'm used to it.
He's used to it from me.
Understand. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Excuse me?
Do you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes.
And do you understand that these are all adjudications of guilt for felony charges, at least 2 out of the 3, so you'd be a convicted felon?
Yes, sir.
Okay, just want to make sure you understand all those things. All right, and how do you plead to the lesser included offense of disorderly conduct?
No contents.
And how do you plead to the 2 counts of the felony battery?
Contents.
And this is the state's agreement.
It is, Your Honor. And for the record, I already gave the probation the two victims' names. It's Alexis Millington and Jacob Santiago. And they already have it.
Okay.
Thank you, Mr. Sheet.
All right. Mr. Allen looks a little confused by the
No,
name.
no.
Okay.
No, I'm good.
I just wanted to make sure if there was a situation where we had the wrong.
Can I just explain really quickly, Judge?
Sure, go ahead.
Yes, thank you, Your Honor.
All right, I'm going to accept your pleas of no contest to disorderly conduct and ask charge to the felony batteries. As to the disorderly conduct, adjudication of guilt, time served, $270 court costs, $100 cost of defense, 90 days from your release to pay those. You can probably set up a payment plan with the clerk's office. Just make sure you go into the on the first floor here. I guess you live in Fort Walton. You can do that at the Fort Walton courthouse as well, since that'll be closer for you. On the two felony cases, adjudication of guilt, 2 years probation, $867 court costs, $100 cost of defense, anger, excuse me, anger management course, no contact with the victims who were just named. You understand all that?
Sir.
And this is a guideline sentence. I've reviewed the amended guidelines. Any objection to those, Ms. Jaquith?
No, Your Honor.
All right.
We would ask that the court waive the cost of supervision, however.
Cost of supervision will be waived based on him being indigent as he's represented by RCC.
Sure, when you get released.
All right, I need you to be fingerprinted. I need you to talk to probation before you leave the courtroom, Mr. Allen, and then you have 30 days to appeal the judgment and sentence of the court. Thank you, sir.
That's fine. He's not, you guys don't have him.
Excuse me. Who do I talk to about being assaulted?
I'm sorry, I can't hear him.
I'll speak to him, Judge. I'm not sure who.
Your Honor, I have somebody on the docket named Ricardo Bryan in 18 CF 1425. Mr. Bryan is in Graceville, CI. I don't really know why this is on a pretrial conference date. I was going to propose moving that to May 29th for a status. My intent would be to call his classification officer, make an appointment with him, so I can talk to him on the phone and figure out what the nature of his claims are.
Well, is this a post-conviction case?
It is, Your Honor. Mr. Bryan's, he's under at least a 30-year sentence.
I saw 2058 was his release.
Yeah, it's a ways away. So
Is that based on this case?
I believe it is,
Okay.
Your Honor.
All right, so let's put him on May 29th. Any preference on morning or afternoon?
I would prefer morning. I don't intend on having him transported for that hearing. I just want to keep him up. I want to keep Your Honor updated on what the
Sure, I
progress
appreciate it.
is going on there.
All right, let's put him on the morning at 9 o'clock. It's
Okay.
a pretty full docket, but this one doesn't sound like it'll be terribly long.
Yes, sir. Yep. Is he here? Yes, I have Mr. Seth Talbot. I tried to meet with him at the jail yesterday. I was informed by his fellow inmates that he's currently in Santa Rosa County Jail on federal charges. So I would ask the court to continue that to the June 24th docket, and I will.
That's Talbot, who's got 4 cases on.
Yes, he starts on page 30 of the docket.
All right, so he's got the 3 VOPs, 20 CF 2428, 21 CF 2077, 23 CF 38, and then the new charge of 24 CF 2608. I'm sure you're aware, Mr. Kleins, if someone's on federal charges, it's very difficult to get them transported over.
Well, I was just, as you were talking, I was like, well, I'm going to probably have to drive over to Santa Rosa County.
May I request a capias for the purpose of, because if we set it for next date, we may not have the defendant here for the reason that the court explained.
Well, until if he's got federal charges, and I don't know anything about that other than what you just said, Mr. Kleins, they're not going to let him out of there until those cases are resolved. Case or cases, I don't know.
I would just request, and I understand the state's position, I would request that the court not issue the capias at this time, put him on the June 24th docket. If he's not in custody in any institution at that time, I would obviously advise the state, he's been released somehow, but I don't expect him to be released anytime soon.
Santa Rosa notice the jail website will show if someone has a hold. So if they have a hold for us, then we probably don't need the capias, but. The only hold listed is USM, which is the marshal's office. So.
And one of the problems that I've always noticed with the jail's website, Your Honor, is if they are listed in another institution, they are never formally booked out. So I have no idea when Mr. Talbot was actually transported to Santa Rosa County. We could tell by looking at his.
Got there.
I was gonna say, we could tell by
February
his booking information in Santa Rosa County.
February 28th.
Okay, and this was, information relayed to me from some inmates, so, but.
But the fact that he has VOPs.
I'll defer to the court. I mean,
I'm going to do a capias with a hold, and then obviously we'll address it once he gets back. I just want to make sure that gets back to us so we can resolve his case.
Understood. My intent, though, before June 24th is going to be to drive out to the Santa Rosa County Jail, talk to him, figure out what's going on. So, but in the meantime, I will be setting depositions if they haven't already been set. I mean, I'm trying to get cases resolved as quick as I can.
No, I appreciate it.
And normally, if the federal government decides to proceed with the charges at the federal level, normally we relinquish jurisdiction. So we would have to deal just with the VOP cases at that
Certainly.
point, and I will notify you as soon as I find out.
Absolutely.
Do we know, is it the same facts that are leading to the federal charges?
I'll check on that. When I was in the public defender's office, I had a client who's pending sentencing on May 15th. That the state has not dropped those charges specifically to see what happens with the federal charges. So I'm just coming out of a situation kind of similar to this. So when I go talk to him, I'll advise the state, this is what he's looking at, what he's charged with.
Very well.
And just as a quick suggestion, you might want to call ahead too before you drive to make sure.
I will. I've never been over there, so.
I've tried to get people who were in federal custody just to be a witness in a case when I was in Escambia County, and they were polite enough not to laugh at me when I asked for them to be transported to testify in a case, but.
Understood.
There's usually a lot more restrictions, so you might want to call.
I have no doubt, and I fully expect that with an inmate in federal custody.
All right,
So.
thank you, Mr. Clark.
Yes, sir. Your Honor, this is Cordell Thomas. I have him in 24 CF 906. I know Mr. Maddox has him on a, I don't know the case number.
Yes, Your Honor, 24 CF 2845.
On my case, Your Honor, on the 906, Mr. Thomas already has a motion to suppress. It is scheduled for May 29th. So if we could just continue this to my case to the May 29th docket.
All right, I noticed that y'all have some depositions set for May 2nd. Is that on the same case?
I believe so, yes, Your Honor.
It's on the case that has the motion.
Yes.
What about your case while he's up here, Mr.
Your Honor, I
Maddox?
spoke to Mr. Thomas this morning about a continuance in his case. He's amenable to it. Your Honor, I'm going to schedule depositions in his case with me as well.
Okay. All right, so Mr. Thomas, we're going to put you on June 24th for pretrial purposes at 9 o'clock.
All right.
But you're going to have a motion to suppress hearing set before me on May 29th.
Yes,
Mr.
sir.
Thomas, let's just make sure we button
Oh,
up a little bit
sorry,
more
sir.
next time, too.
Is
Oh, I understand, but,
Dave messed up.
well,
I'm sorry.
then tell them when you get back that
I
I would like you
apologize,
to
sir.
have a jumpsuit that's more your size.
All right, man.
All right.
I'll get this back to you as soon as I can.
You said that was the June 24th date,
June
Your Honor, for my
24th
case.
on both cases for pretrial, but obviously the
906, I
the
think.
906 case?
904?
906.
906.
Case will be on 529 for purposes of the motion. All right, thank you, Mr. Thomas.
Your Honor, this is Mr. Calvin Tipton. He's got 16 CF 1262 and 22 CF 894. The 1262 case, I believe, is a violation. I met with Mr. Tipton at the jail yesterday for the first time. I talked with Ms. Basso this morning. My understanding is that the current offer for Mr. Tipton is 40 years. The state would be open to a counteroffer. I briefly talked about this with Mr. Tipton yesterday, but in full candor, when I was meeting with these clients yesterday, I was basically telling them, I'm still figuring out the computer system we're using, so I haven't even really reviewed discovery. If we could continue Mr. Tipton's cases to the June 24th docket, my intent on all of these inmates that are being continued is to go up to the jail in the next 2 weeks. Once I can figure out how to read the discovery and go over the discovery with them, So that's kind of what we're doing with these cases.
And that's without objection, Your Honor. There's also some depositions in those cases, Mr. Klein's, I believe, over in the system as well.
Thank you.
As far as transcripts? Or, okay. I just,
If Ms. Flowers had them transcribed, otherwise the recording should be.
okay. All right. You understand all that, Mr. Tipton?
Yes.
Okay, just want to make sure.
Thank you.
All right, Mr. Klein is going to be your lawyer going forward. We'll see you back on June 24th at 9 o'clock.
I'll see you in a couple weeks, Mr. Tipton. Your Honor, this is Stephen Arp in 22 CF 1833. At this time, Mr. Arp is going to be asking the court to continue this. I did meet with him at the jail yesterday. I understand this is a failure to appear. That's
Jury trial date.
correct. So I would ask to continue this. I don't believe Mr. Arp has any issues with that. Again, I need to go over the discovery and kind of figure out what exactly was happening last year.
You understand that, Mr. Arp?
That's correct, Judge.
Yes.
We have no objection. For some reason, the FTA was put in Judge Clark's division, so I asked my secretary to do a motion in order to bring it up here to coincide with his original.
That's why I was like, I swear there's two cases. Like, so, and
If
I
it
actually
was assigned to like the PD's office or anything, I just want to make sure that all the paperwork gets done so that it gets to Mr. Klein's too.
I believe the public defender in Judge Clark's division was assigned, as well as an ASA down there, but I've asked my secretary to move it up here.
Once it gets over here, just make sure the paperwork goes through so I can get you assigned to it, Mr. Klein's.
Absolutely.
Otherwise, having two different lawyers on basically the same
I
case.
think that's a total waste of resources. So,
Just for Mr. Klein's information, as charged with the FTA, he scores 65.4 months with a max of 15 years.
thank you. I appreciate that. Okay, I'll come talk to you. I believe that's all I have on the morning docket. If I may be excused, Your Honor.
Yes, sir.
Thank you. I'll see you on Monday.
Good morning, Your Honor. May it please the court, Brad Stewart on behalf of James Carnes, Judge. This is 22 CF 1268 and 24 CF 2782. Your Honor, we received discovery last week. This is the first time up. We do need to continue this. I anticipate depositions and motion practice.
Objections? Continuance?
It's Josh's case.
Oh, it's Mr. Sheik's case?
It's Josh's case, no objection, Your Honor. I'm sure Mr. Stewart has spoken with, yeah, Mr. Sheik.
All right, June 24th at 9 o'clock for your next court date. Let's see if we can get those depots and motions set up.
Yes, Your Honor.
Thank you, Mr. Carnes.
Your Honor, Brad Stewart for Dylan Grantham, Judge. This is 24 CF 1482. This may be an add-on on the docket, Judge.
I think I did see that it was an add-on, so let me. All right, what are we doing with it?
Your Honor, at this time, Mr. Grantham is prepared to admit the violation of probation. I do have a sentencing agreement that is signed by all parties, if I may approach. And, Your Honor, if I may, this is a modification of the existing probation to a new one-year term on community control that will be followed by a 1 year of standard reporting probation. He has to complete the Emerald Coast Life Center program or similar program, reimpose previously ordered probation requirements. Those are court costs as reflected in the written plea agreement, maintain employment or submit 5 job applications weekly. There's a $100 VOP fee in addition to the previous fines and costs. You must do weekly urine analysis for the first 6 months, then it shall convert to random urine analysis. Judge, from a posture standpoint, this one is a bit odd.
So I'm trying to figure that out as you're talking, Mr. Stewart.
He was originally taken into drug court, Judge, but because of the logistics, Mr. Grantham lives on the north end, does not have reliable transportation to make it to the south end. Judge Ward did allow him to withdraw that plea and place him back on the docket. Therefore, there was a $500 cost for drug court that was assessed. I would request that that be removed, and I'm requesting that we waive cost of supervision based on what Mr. Grantham owes and must complete, and he's been incarcerated since his removal from drug court.
All right, and just to make sure it's clear, the CT case is still resolved by the original plea.
That's correct. That CT case has been...
Just costs. I just want to make sure that it didn't get lost or brought back up. All right, Mr. Grantham, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name and date of birth?
Dylan Grantham, 11/15/1993.
Okay, and Mr. Grantham, again, you're here in 24 CF 1482. We're here regarding a modification of your existing probation. As your attorney said, it originally was to be drug court, but because of the issues of it being in the south end, we're modifying it to be a new 1-year term of community control followed by 1 year of standard probation. You're going to have to complete the Emerald Coast Life Center or ECLC program or similar program, reimpose all previously ordered probation requirements, pay $100 cost of prosecution, $415 in court costs, $150 PD fee, maintain employment or submit 5 job applications weekly, $100 VOP, weekly UAs for the first 6 months, and then random. Is that what you wanted to do here today?
Yes, sir.
Did you go over this agreement with your attorney, Mr. Stewart?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
Yes, sir.
And has anyone forced, pressured, or threatened you in any way to enter?
Yes, sir.
Has anyone promised you anything in return for your plea?
Yes, sir.
Do you understand that by entering this agreement, you're giving up your right to an evidentiary hearing where they have to prove that you violated your probation in some way?
Yes, sir.
And do you understand that you're waiving any potential defenses that you may have had?
Sir, I think
You're
yes,
waiving
sir.
any potential defenses
Yes,
to
sir.
the violation? Okay. And are you admitting or denying your violation of probation?
I admit it.
Admit. Okay, and it's a continued withhold?
Yes, Your Honor,
That's the
and the
state's agreement?
modification.
It is, Your Honor.
Okay.
And I don't believe the score sheet is required under the
There's
modification.
a modification. Yes, sir. All right, so I'm going to accept your admission to your violation of probation as freely, voluntarily, knowingly given. Modify the existing probation to a new 1-year term of community control followed by 1 year standard probation, ECLC program or similar. Reimpose all previously ordered probation requirements. Pay $100 cost of prosecution, $415 court costs, $150 PD fee. Maintain employment or submit 5 job applications weekly, $100 VOP fee. Weekly UAs for the first 6 months, and then convert into random urinalysis, and then we'll go ahead and remove the $500 drug court trust fund cost because you didn't actually go through the program. And I'll waive cost of supervision due to the fact that you've been found indigent previously. Anything that I've missed?
No, Your Honor.
All right, go talk to probation before you leave, and you have 30 days to appeal the judgment and sentence of this court.
Yes, sir.
Mr. Grantham.
And Your Honor, from probation standpoint, for clarification, his original termination date is February the 12th to 28th. We're going 1 year community control followed by 1 year probation. Are we stopping there, or are we
Yes.
going all the way to the end?
No, it's just the 1 year community control from today, 1 year probation once that stops. So he'll be done, April 30th or so of 2027 is the agreement. All right. Go ahead, Mr. Stewart.
Thank you, Your Honor. For the record, Brad Stewart on behalf of Donald Jesperson, Judge. This is 23 CF 1008, 1009, 24 CF 368, 25 CF 36, Your Honor. We have set up another round of depositions to include a final deposition in the trafficking case, as well as initial depositions in the new law violation 2025 case, Judge. We are moving this case forward. At this point, I do need to request a continuance so we can perfect that.
What are those depots set, Mr. Stewart?
Judge, I believe that they're at the end of May, if I'm not mistaken. I'm going to say the 24th. Does that sound right?
Sounds right.
All right, so Mr. Jesperson, we'll see you back on June 24th. Obviously, if you have the depositions and something gets worked out, you can try to bring it in a little bit earlier. But otherwise, we'll see you on June 24th.
Your Honor, that's all I have before the court may be excused.
Yes, sir.
Thank you, Your Honor.
You're welcome.
Hey, Judge, good morning.
Morning.
I've got Felicia Johnson, two cases, 24 CF 2693 and 25324. First time up, Judge.
Say again. Say again, Mr. Powell.
It's the first time up, and
What would you like?
we need to continue it. We got to take a lot of depositions, and
A lot
the
of
state hasn't been able to
depositions?
send the discovery.
Any objection from the state?
No, Your Honor.
All right, June 24th at 9 o'clock for next pretrial conference in order to set depositions.
Thanks, Judge. That's all I got.
All right, have a good day.
I'll call you, okay?
Yes, sir. Thank you.
Mr. Ray? Oh, he's unrepresented. Morning, Mr. McDonald.
Good morning, sir. How you doing?
I'm doing great. How are you?
All right.
All right.
I could be better.
All right, Mr. McDonald, obviously, just to bring it up, because we have to talk about it every time we're here for
I know.
a critical event in your case. You're currently representing yourself, is that correct?
Yes, sir, I am.
All right, raise your right hand, please. Do you, testimony about to give the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Do you still want to proceed as your own attorney?
Yes, sir, I do.
Okay, are you still aware of the advantages of having an attorney?
Yes, sir.
Are you still aware of the disadvantages of not having an attorney?
Absolutely.
I mean, we've gone over this before. I want to make sure I say this too, because of some other recent case law. I'm not trying to encourage you to have a lawyer or anything like that, but I still have to ask you those questions
Yes,
and make
sir.
sure that you want to proceed on your own.
Yes, sir.
Is that accurate, that you want to proceed on your own still?
Yes, sir.
Okay, again, if you ever decide that you'd like a lawyer, you can file the appropriate application, and I can, if you're found indigent, I can certainly appoint a lawyer for you.
Yes, sir, I
All
understand
right,
that.
so how would you like to handle your case? I know last time we were here, we talked about, you had asked several times about a pretrial adversarial hearing, and we talked about that, made sure you understood what that was, that the probable cause determination had been made at your first appearance, and information was filed in a timely fashion. So I'm not sure that one really applied. And you were at that point, you were like, well, there's something else I'm talking about, but I can't remember the name of it off the top of my head.
Yeah, just to revisit that for one moment without wasting the court's time, is that I had never went to first appearance initially. And so that's why I filed that for that non-adversarial hearing.
You never went to first appearance?
I never went to first appearance for that, and that's why I filed that, and I was under that impression. And therefore, when you said that I was not allowed to have that, then
Let's see.
there is no recording of that, of a first appearance for that
Just take a quick look at it.
recommitment of.
Is that on both cases you're saying that's the case? Is that
Well,
on both cases
the-
you're saying you didn't have first appearance?
No, sir, I did not. Not 1950 case,
Not the 1950?
not the 1950.
So you're saying
For
in
the 2917.
2917
Yes, sir.
case, you never saw a judge for first appearance?
No, I did not. There is no recording for that.
Well, here's the situation. I'm looking at the first appearance paperwork, Mr.
Yes.
McDonald. On December 23rd, 2024, you refused to come to first appearance?
No,
according
I
to the
did not
whole-
refuse it.
Let me finish. And then again on 2024, 12/24 of 24, it says that you refused. So,
Is my signature on it?
well, no, because you refused.
I don't remember refusing that.
Okay, so a probable cause, it's called a non-adversarial probable cause determination, which
Right.
means the court makes it based on, what the report says.
The A form?
Yeah, some people call it an A form, some call it a PCA, a probable cause affidavit. I practice in pretty heavily in at least 5 different circuits, and I think it's called something different, just
Every
like
one
almost
of them.
everything's called something different in every circuit. So yeah, it's an A form, it's a PCA, it's an arrest report, that's why they call it non-adversarial. It's not an adversarial hearing.
Yes.
And then as far as the other thing you were talking about is, if you hadn't been charged, but you have been.
Well, I had been, yes.
So I just wanted to make sure we kind of had discussed that. I went back and watched it again yesterday just to remember, because obviously you're appearing pro se, and I want to make sure I'm reviewing those things.
I understand that you said.
So
that
how would
looked
you
at
like
my
to
stuff.
proceed with your case? Because I know we talked about, your alibi witnesses and you want them subpoenaed.
Yes.
But I really need to know what exactly you're wanting as far as what you want set for a hearing, because Mr. McDonald, you filed quite a few things with the clerk's office. I told you this last time, when they come in, I get an email, I read them.
Yes.
But I have to make sure I understand what you want set and why, because I'm not trying to be critical, Mr. McDonald, but obviously,
Understand that.
you haven't done this before, really, right?
I have done it in a civil realm.
In a civil realm, but in a
Yes.
criminal case, because you don't have the access to just get on and e-file something and.
Yeah, I
then-
don't have
and
that
then-
access. I don't have access to a computer. I don't have a Black's Law Dictionary. So sometimes, it struggles, and then I have to read it to understand it. But it's not that I don't have a basic knowledge of it. The thing is that I have filed, the last time we were here, I spoke about that it was not warranted about the notice of discovery. I've not received no discoveries at all.
Has the
None.
state filed sent discovery? I think we talked about it last time, because we specifically
Yes,
talked
and
about.
it wasn't warranted at the
Mr.
time.
McDonald, I'm not interrupting you. Can you, everything
Okay.
has to be said on the record. I want to make sure the recording's good, so a transcript can be made. This is to protect your rights. But let me just finish. I know we talked about it last time, because again, I reviewed the video recording of it yesterday in preparation for today.
Yes, sir.
And we talked about that the state would mail you, because we even talked about the fact that it comes in and they scan it and they put it on some sort of tablet for you, which you weren't happy with. And I'll tell you the same thing I told you back 2 months ago. I don't have any control on jail policy as to how that stuff works. But has discovery been mailed to Mr. McDonald?
I believe it does. I was double checking now with my assistant. The other thing, Your Honor, most definitely we can deliver even the paper discovery, the reports and all of that. Via the
I
investigator, like
understand
we
you
can drop
can
it
do
off.
it. Has it not been done?
It might have been mailed out. I'm checking, Your Honor, to verify.
I don't know what page he's on. Does he go before RCC? Here, I found him, 26.
We did send it, Your Honor, probably to his previous counsel. Obviously, we haven't sent the brand-new cases that he was arrested for recently. I haven't even reviewed the very last one yet.
Okay, when did you ask for a discovery on?
On, no,
the new
on,
case?
on January 31st
Okay.
is when I sent for notice of discovery. I do believe. Let me check my documentation. Notice of alibi. Oh, no. Yeah, January 30th, 2025, notice of discovery sent to clerk, judge, and state attorney.
Okay, I see. But what I have, and you said February 3rd, but I get it, my date is based on when it got
Yeah, when it got
to the
into
clerk's office, which was February 6th, is called Defendant's Discovery Exhibit. And
I didn't file it as an exhibit.
I just want to make sure that we're all on the same page.
Yes.
These are the people you're saying are defense witnesses, right?
Right.
Did you file a notice to participate in discovery?
Notice of discovery is what I filed, Your Honor.
When was that?
On January 30th. It's in my documentation.
Oh, okay, I'm just trying to find it, sir. You think you mailed it on January 30th?
I did mail it.
I'm just making sure, again, when we're talking about which date, so I can find
Yes,
it.
well, I mailed it on the 30th, so the clerk of court should have received it on the 3rd at the latest, maybe the 4th.
I just don't see anything on those dates, that's why I'm trying to make sure. Because the only thing I see is on February 6th is the motion, it's called Defendant's Discovery Exhibit, and it's you saying, these are the witnesses that I have.
No, that was my obligation to the notice of discovery. I don't know why it's not registering that, because I filed a notice of discovery.
I'm reading what you titled it.
Yes, sir.
And I'm reading what you put on there, which is you listed witnesses. What you didn't say, and let me just finish reading through it. Is that you're electing to participate in discovery. Now, one could certainly imply or assume that's what you intended, but the state doesn't have to give you discovery until you ask for it, and your document doesn't exactly do that. And I'm not trying to be hypercritical here, but just making sure, because what happens is if you never ask for discovery, then you're not required to provide any of the discovery you want to give them. It's an election by the defendant to participate in discovery.
I have the memorandum at the jail. I didn't bring it with me today, but I have the memorandum from the clerk's office stating that I filed a notice of discovery.
I'm trying to find it. I see a discovery exhibit was sent.
Yeah, we did send all discovery to his
The
attorney.
defender's office. Yes.
In two cases, 24 CF 1950 and 24 CF 2917. As of, in 24 CF 1950, we sent up to the fourth amended discovery and at the end of January 2025. In 24 2917, we sent it on January 25th to Defense Counsel. We have not yet reviewed 25 CF 713. We haven't even filed any information on that.
A 713?
Yes, it's a brand new case, 25 CF 713.
Is that on this docket?
It may not be on this docket, no, Your Honor, because I'm just saying that if he's expecting that discovery for the newest case, I don't have it ready.
No, I didn't file for that. I had already filed a notice of discovery on the 30th of January. I don't know why I didn't do that. If I knew that was going to be an issue, I would have brought the memorandum.
Mr. McDonald, it's not about an issue or not. I'm just trying to make sure things are being done.
Yes.
But you have to file something that triggers them to have to act. And all I've seen so far, and I'm trying to look at the 1950 case now, is anything.
Your Honor.
Hold on. So what I'm finding now in the 1950 case is a notice of discovery that you did that was received on February 11th. And although it has both case numbers on it,
Right.
it's only in the 1950 case,
Okay.
because that's probably the top one. Normally, it's better, and I know you've got limited resources as far as the paper
Yes.
to write it on, but if I could, I mean, Anna, is that something where they would normally just put it in both, if it's got both case numbers on it?
I consolidated it, and then I sent.
Well, no, there's no consolidating a criminal case like this
Because
unless they're about the same facts.
the
But
ability
I
to-
understand what you're saying.
Yes.
I'm just trying to make sure that when you do that, they end up in both court cases, because that may
Yes.
be the issue is,
It
it only went to, one file and not both. And Ms. McDonald, I'm doing this not to be difficult, I'm doing this to try to make sure things are going correctly.
Fairly.
Because normally what a defense lawyer would do is e-file it under both case numbers, so it makes sure to get there. So, all right. So, what do you think you're missing as far as discovery at this point?
All of it.
You don't have anything?
I
Even the
even
stuff
wrote-
that was provided to the public defender's office when they were representing you?
I asked him, I sent him a correspondence, when we left here in February, and requested it from his office too. Nothing.
Judge, we've asked, or I've asked my secretary to send over discovery to him.
All
I'll
right.
check with
This
her.
is what I'm going to order.
Yes, sir.
State is going to send over a copy of all previous discovery that's been done, and obviously any amended discovery exhibits, in the mail to Mr. McDonald no later than tomorrow. It just needs to be done, because Mr. McDonald doesn't have the ability to constantly come back in front of the court, and doesn't have the same resources that a lawyer would. So I want to make sure that's done. And I'm not trying to be difficult about it, but y'all got to get that stuff over to him. I understand what probably the concern is with the 2917 case, is that the notice of discovery was never filed in that file, even though he wrote that case number on the one that he filed. So that's probably where the problem was. You have to understand, Mr. McDonald, when they churn through literally thousands of cases, if the case number isn't on there properly, it doesn't get e-filed the way their system usually takes it, it might not end up in there, so that you've got to make sure it gets into each file. So you're actually better off doing separate ones for each case. Because cases don't get consolidated.
I think I went and sent the clerk, and requested that, to clarify that I wanted to clarify that and that they were separate, notices. But I understand, I see that you see it, so you know it was sent.
I see
and
it
that I did
now.
it in a proper manner, so it wasn't technically done in separate forms. So I do understand
So
that.
make sure all discovery gets done in the first two cases, for sure. Did you file something on the new case? We don't have, you've got court on that next.
I filed an
next
objection to the probable cause for lack of probable cause, and I filed a writ of habeas corpus on it because I didn't have prompt first appearance, and I filed a motion to dismiss it because it's under circumstantial evidence, there's no link for me.
I'm not sure, you're speaking way too fast, Mr.
Yeah.
McDonald.
Well, I just familiarize myself with it so much. I mean, that's all I have time to do is just do legal work and study it.
Well, I understand. But I'm talking about the new case, the 25 CF 713. You had a
Yes, and
first
that's what I'm
appearance.
talking about.
You had a first appearance on that.
No, I did
I
not.
see your signature right here.
No, Your Honor, that is not correct. I was already incarcerated. I asked the pretrial lady there that I had already previously, when I had arrested on that, to call Brad Stewart's office. I did. I had my family members call Brad Stewart's office so I could get represented by an attorney for that first appearance.
I understand, but you had a first appearance on April 8th.
No, I did
You
not.
signed the paperwork.
I got arrested on the 4th of April, and on the 5th of April, I was to be in first appearance, and when I went to the video prompt, the pretrial lady called me, if I was the first one we called, I said, look, I'm trying to get an attorney for this first appearance hearing.
Your Honor, may I ask to set this matter for a motion hearing so that we don't hold the court's time? And
Yeah, I understand. Mr. McDonald, well, I think what we need to do is set a hearing date,
Okay.
but I need to know what motions you want to have heard,
On the hearing date for what case, Your Honor?
or whatever you'd like to have heard.
I
Mr.
would-
McDonald, you filed a lot of things in all of these cases.
Okay, and
A
then,
lot of them aren't exactly correct. And again, I'm not trying to be critical, but
Right.
but I'm trying to get you to explain to me which motions you've made and that you'd like to have heard.
okay, for the record, Your Honor, for the 1950 case, I filed a motion to compel after the request for the notice of discovery, and a motion in limine, and like to have a hearing date set for that.
Did you file a motion in limine?
Yes, I did,
What date
in the
was that?
1950 case.
In the 1950 case. When did you file that? I've got one that's listed as February 24th.
That may be it.
You know, I would ask that we determine with precision the motions that are going to be heard, because obviously I need to respond, I need to prepare for them, but it's impossible based on the number of frivolous filings that this defendant has filed in the cases. And additionally, I have to say that I have a great difficulty trying to interpret his handwriting. I understand he's got difficulties, but I don't know if he can have access to some kind of laptops so he can type instead of handwriting that, because it's really, really hard.
There is one available, but they won't allow me to have one.
Well, I think I said this last time. Sometimes the handwritten motions look great, sometimes not so much. And it looks like so much, I think we talked about this last time too, writing all capitals or block letters, that's the same way I write, but some of them are a little difficult to comprehend. So I understand the state's position on that, so. Normally, we don't do our motions in limine until the case is set for trial. So let's see, what other motions do you want to have heard?
In the 2917 case, I filed a motion to dismiss that based on the alibi witnesses, and that I was physically impossible to be there on that date.
So for instance, Your Honor, this motion to dismiss could not be heard because, for example, I have a right to depose this potential alibi witness that he has,
Okay,
and I don't even know who that person is.
trying to find, when was the motion to dismiss filed?
I didn't bring the memorandum with me on that, Your Honor, not today. I'm sorry.
May I propose something, Your Honor? Can we come back on Monday, and so Mr. McDonald has the time to maybe write the court and myself a list of what he really wants to set for a hearing?
I can do that.
So we may have more time to discuss that on Monday during docket day.
I'll have that in the mail this evening for her.
All right, we're going to bring you back on Monday.
Okay.
Give us a list of what you want to have heard.
Okay.
And I would like, I mean, Ms. Leone, if his discovery could potentially be delivered to the jail before then, that would be great.
I will try, Your Honor. I'll have our investigator. He was not in the office today, but hopefully tomorrow he is.
All right, see if they can drop it off at least, that way he'll have it before Monday. And then we'll use Monday as a way to kind of figure out what motions we're going to have set. But you've got to be prepared to tell us what exactly you're looking for, because again, Mr. McDonald, I've read all these, and sometimes they're not easy to understand what you're
Okay.
asking for, or you're asking for things under the wrong rule, or you're not complying with the rule. So I just want to make sure that we're covering everything, but they have to be done correctly. You know, just because you're pro se doesn't mean I can, kind of give you a break on
understand
some
that.
of these things.
And I don't have all the ability that's afforded to others, if I was on the street.
Well, I understand that, but
But I will have Mrs. Leon's in the mail tonight. She may not get it till Saturday.
well, I would expect she's probably not going to get it at all if it's not mailed out. And
I'm having it mailed tonight.
We'll see if she gets it or not.
Okay.
All right.
Thank you,
Mr.
Your Honor.
McDonald. We'll see you back on Monday.
Yes, sir. Judge, this is Ronald Allen. Mr. Allen was recently returned from the Florida State Hospital. I think we had him in either April 1st or April 10th. He was set on a relatively short date because I'd proposed time served with the credit that he had for all the time that he'd been in Florida State Hospital. The state was going to reach out to the alleged victims. I haven't received an offer on it as yet. I don't know if they've been able to. We did get some information from family, some documentation, and I just asked my secretary to send that over. If it's not going to be able to be resolved with time served, then we're going to have NGI evaluation done on him. We had originally scheduled one, but Dr. Zeman, given how incompetent he was when he initially saw him, could not do that evaluation, needed him restored to competency before he could and be in a position to be able to answer questions as a good historian before he could address that issue.
Okay, so he's been found to be competent, but you're talking about NGRI, so for a different evaluation.
Yes, sir. Basically, he was returned from the state hospital as being competent. I think we went ahead and did the competency evaluation last time. If the clerk's record's not saying that, we'll stipulate to the report, and the court can go ahead and handle that today.
When was the report filed?
It was from Florida State Hospital, so it would be before his previous court appearance. I've got the file here. I'll look and see what the date is on the one that I have.
This is James Allen?
Ronald Allen. Ronald Wayne Allen, and the case number on its judge is 2021 CF 967. I think one of the issues in the case is he's been in.
Anybody have any idea what page of the docket it's on? It's not under your name, that's why.
I think it's listed under RCC, Your Honor.
I see it under Gibbs, I believe, Your Honor.
Under Gibbs, so.
It looks like the evaluation was to the court on March 25th, and then he was brought in to be put back on the docket. And it looks actually like there was a competency hearing scheduled for April 10th at 2 o'clock.
I found that he was competent, but I don't think I've ever received an order. But I'm looking at the.
Judge, I can check on that. I thought the state hospital provided that.
I guess someone would have to communicate with the state hospital that I granted the competency order.
Well, I have my secretary fix it,
Okay,
Judge.
if you could, just, I know they're usually pretty, it's form. It's the same thing we use on pretty much every case, but I made the ruling on 410, but I just haven't seen an order on it. So what's the state's position on what we're doing here today?
I was reviewing the notes. It's an older case, of course. There was another prosecutor assigned prior to me. The offer in the file is for 15 years concurrent on counts 1 and 2. And
Which case?
I think
It's one case. It's one case. I'm
yes,
sorry.
sir.
Go ahead.
Followed by 3 years of probation on counts 3 and 4, and count 5, credit for time served, adjudication of guilt.
Judge, we're not going to be doing that. I'll go ahead and move to continue it, and we'll get the NGI evaluation done.
All right, let's put on 6/24 at 9 o'clock.
Thank you, Judge. All right, I'm going to add you to my list for tomorrow, okay? That's 6/24, Judge?
Yes.
What's your name, sir?
Judge
Judges, Camden Barnum, case number for the record is 22 CF 3192. At this time, we're going to ask for a continuance. I believe the case is still under Mr. Gibbs' name, but we're going to take care of that. We've got an attorney assigned to the case, but she's not going to take it until after this week.
Just for the rest of today, if y'all could try to tell me who it's under or what page it's under. I've got it. He's right on it under the last person. I've got it for this one, just because I think all of you are handling cases that are under names that aren't yours. And I'm not trying to be critical. I know it's a lot to fix, but just to help us go through it today.
Yes, sir.
If you could tell me which, but I've got him as number 53 on page 33. What else needs to be done? I know you're new to the case, Mr. Russell, but.
Yes, sir. As I understand it, there were some depositions taken, but there's still some that remain. And so she's going to have to take care of setting those depots.
This case is almost 2.5 years old. So
yes.
I just want to make sure that we're making some sort of progress.
Yes, sir. And I'll explain that to her, that if nothing else, get the depots set so that at least the notices are filed so that everybody can be on the same page.
Yes, sir. I received information from Ms. Glisson, and she had discussed this with Mr. Russell, and she's not objecting to continuing it.
I really want to see some progress as to what's going on with this case between now and the next pretrial, because again, it's been quite some time. I know it's a very serious case, but it sounds like not a lot was done under previous counsel, and that needs to be fixed quickly.
I'll emphasize that.
All right, Mr. Barnum, it's going to be June 24th at 9 o'clock.
Judge, I'm sorry.
70 on the docket, Judge.
I've got it, brother. Thank you. I think he's the last person on the docket.
We're still awaiting the court's written order.
And I've given my ruling. I just haven't finished the order. I was hoping to finish that yesterday, as I told you, Mr. Williams, and I called up someone from the state just to tell them that Ms. Sandler. Unfortunately, I had somewhat of an emergency situation with a case yesterday where an hour-and-a-half hearing took up about 4 hours of my time. So you'll certainly have it by the end of the week.
Yes, sir.
Because I think I've got some actual free time tomorrow. So I apologize again for that. That's why I wanted to make sure you guys knew my ruling so you could discuss what you might want to do going forward. But I'll spell it out as I know, Ms. Sandler, you received one of my orders on a similar case recently. It's not a 2-page order.
Yes.
My last one was about 15 pages. I like to make sure I cover everything so you understand what my ruling was and why I ruled that way, and that the District Court of Appeal, if they see it, knows exactly how I ruled and why I ruled that way. So I want to make sure I'm taking enough time on it. Unfortunately, because of the issues that we had with getting the transcripts and then the kind of delay that caused for you to get me written arguments, I had to go back and review the entire hearing again, which was 2 days. Because at that point, it's as much as I remember it as I go through it, it's hard to do that and remember all the details with after 2 to 3 months of waiting. So again, I'm not trying to be critical. It was just a little bit snake bit from the beginning. But I want to make sure I get you a full order, Mr. Norris.
Once I receive it, Judge, I'll bring a copy of it out to Mr. Norris, and I'll review it, and from there, I'll make my decision on whether or not we're going to do a writ of prohibition or whether we're going to go ahead and proceed.
Okay.
And the state will go ahead and file motions in limine and all that based on the court's oral ruling,
Okay.
just to be prepared for trial this cycle.
So we'll leave it on for the 5th, which is next Monday. And then if you could, Mr. Williams, again, I'm going to do my best to have it to you tomorrow. I just hate to promise things because it seems like lately every time I do, things blow up on me.
Judge, I think
the last one, I think I filed
Friday,
at 9 o'clock at night because I'm trying to get these things done as soon as I can. And it's unfortunate, but again, I apologize for not getting that done sooner. I'm just trying to make it as full as I can.
I understand, Judge.
Judge.
Thank you, sir.
All right, so we'll keep it on for the 5th for purposes of a potential trial. And we'll see you back on that date.
Thank you, sir.
And Your Honor, that concludes my business with the court. May I be excused?
Yes, thank you.
Thank you.
Is the case you all are still here on, is it Miles? Bunch of you? Are y'all going to be ready to handle that soon, or? Okay. Is Mr. Riasti here too?
He was here.
I saw him. Okay, I just want to make sure what we're doing, because I know we've got 3 defense lawyers and a separate prosecutor just for this case, so I'd like to get y'all out of here if I can, but I just haven't seen everybody in the room at the same time, so. All right, go ahead, Mr. Nopes.
Good morning, Your Honor. Got Andrew Lee Barnhill in 23 CF 1308 and 24 CF 496. Judge, as it pertains to Mr. Barnhill's case, I conveyed the offer the state made. Mr. Barnhill's not willing to accept that. It's our understanding that in 23 CF 1308, and I only know this because the lady that's the victim called my office and we directed her to contact the state attorney's office. I don't believe she wants to prosecute. In the last that I knew, she's vacated the state of Florida and I think lives in Tennessee.
All right. What's the state's position?
Yeah, I don't have that information that the victim wanted to drop the charges. I do believe that she moved out of state, but that doesn't mean that she may not come. We will pay for the expenses for traveling if she needs to come to testify.
Okay. You're not dismissing the case or anything based on a victim's request at this point, right?
No, I'm not. No, I'm not dismissing the case. And then he has the other case of dealing in stolen property where the victim is cooperative.
What would you like to do today, Mr. Nopes?
Judge, I guess, what's your dates for trial?
May 12th and May 19th, but I know I've got several older cases that are kind of in line, although this would be considered one as well. We have to figure out how many we're going to have, get through docket day, and then I'll most likely be seeking out assistance from other judges or senior judges to potentially cover some of these trials if need be.
That actual trial week.
And for the record, Your Honor, the offer that I extended called for 2 years of probation with anger management, no contact with the victims, and just reserve restitution for under 20 days. I'm just putting.
It's on the record.
Yeah.
Let's just put it on for docket day.
Well, I'm going to put it as plea trial.
Okay.
Because the first case you talked about, the 1308 case, is from June of '23, so it's almost 2 years old. And the other case is from February of '24, so it's 14 months old. So these cases need to be resolved. So I'm going to put them down for plea trial.
You know, the state requests that 24 CF 496 be set for trial. I understand the other one is older, but because of witnesses and victims' availability, the state wants to go forward on the 24 case.
I understand. I mean, I know this case has been old, but that goes for both parties. You know, if it's an old case, then it's going to get set for trial. You know, today's pretrial conference, we should know where witnesses are and are we going to be ready or not. So if we're setting it for trial, I mean, do you have an objection, Mr. Nopes, as to which one gets set?
Do not, Judge.
None of this is going to interfere with me.
All right.
I'm sorry?
None of this will be interfere with me being
No
released on my child.
objection to which one gets set, then we'll put the 24 CF.
Posted your bonds, isn't it?
They've been posted.
496 down for plea trial.
Judge.
Come back May 5th at 9 o'clock.
Okay.
Anything else, Mr. Nopes?
You're good on Mr. Barnhill, that's all I got. Then I've got Marcia Knox. That's docket. Judge, Miss Knox is on the docket in 25 CF 92, and also she's under Marcia Reed in 22 CF 1353 on the VOP. I've just been appointed on May 10th. I'd asked to continue it. I want to get discovery and set depots.
No objection, Your Honor.
Did you say May 10th?
I'm sorry?
Did you got a point on May 10th or April 10th?
March 10th.
March 10th.
Signed,
Same
things are-
thing I do, I always say the month with the same letter
That's a sign that things are starting to fall apart, you know, Judge, I'm worried.
Tell everybody, Mr. Gnomes. All right, so you want to put that on 6/24?
That's fine, Judge.
6/24 at 9 o'clock. Is it Miss Knox or Miss Reed? Which?
Miss Reed.
Okay. Make sure I call you the right thing. 'Cause you're on my docket as both, so I just wanted to make sure I'm calling you by your preferred name.
Judge, I then have Terrence Parker. Judge, he's got a number of cases.
Mr. Parker was the one that some cases got assigned to Mr. Cobb, I think, and it took a lot of, for
Yes.
some reason, effort to get them all to you.
They all come to me, and then I believe I just got appointed on another one that's, I was appointed on April 15th on another case, so I don't know if that's, wait a minute. Several of them on March 10th. No. Yeah, anyway. I've got to set depots, Judge. All of these are fairly serious cases.
Looks like there's a 25 MM 708 that's going to be in front of Judge Ward. For- I don't think an information has been filed in that case yet. Oh, and there's 25 CF 518, which is set for a pretrial conference already on the June date.
Okay. We're just going to put them all on June 24th.
Yes, let's go June 24th at 9 o'clock. Misdemeanor has 233 potential counts.
Or? 233.
233 counts of violation of injunction.
That might be a record, Judge.
I mean, that's what he was charged with from the law enforcement. I'm not sure what the state might do with it.
Can't do this morning, knows I can't.
Judge, he doesn't want to accept the state's offer.
Yes, I didn't hear a name or a case number yet.
I'm sorry, William Talbot. 2020 CF 2925 and 22 CF 2507. Judge, it's against my advice.
So, Mr. Talbot, what is the offer? You want to put it on the record?
It was for, called for 60 months DOC without minimum mandatory. However, he's charged with 2 trafficking counts, 1 fentanyl, 1 methamphetamine. We have FTLE on the fentanyl, so I was willing to offer a plea to sale, manufacture, deliver on just 1 count of trafficking so that he wouldn't score and wouldn't qualify for minimum mandatory. I leave the offer open until docket day. However, I intend on getting FTLE to also test the methamphetamines. Normally, we don't ask for the second trafficking amount unless the case goes to trial. But given the fact that he's rejecting the offer and the case is old, I will ask FTLE to do the second report, and we will be ready for trial.
How was this case 2.5 years old?
Judge, this is one of those cases where the officers, we found out through the discovery process that there was another report. If you remember, and we asked for that in December, finally got it in January, and then got depot set. So it was chasing down some additional information. It was a pretty lengthy report, so it was important.
Well, we only scheduled depositions at the end of December of 2024.
When
And
did you take it over, Mr. Gnomes?
Judge, I took it over.
It's 2 years ago.
before I got assigned to it. And I got assigned in end of 2022.
He's been on it ever since. He's about the only one that's been on the case.
Okay.
Yeah.
I had Timothy Gibbs conflicted off, then I had Jennifer Flowers, and Hershey conflicted off for some reason. Now I got him.
Judge, I've had the case for a while, but again, what happened is that we learned of an additional witness and another report, I think the report was 30-something pages. But
There really has to be a better system as to how they deliver those to y'all, to the state. It's just, I can probably tell you 10 stories off the top of my head of showing up for depositions and find out that there were reports that no one had ever seen before other than the witness who was being deposed. So I know it happens, but it shouldn't take the case 2.5 years to get to a resolution because of it. So what else needs to be done? Are we ready to set it for trial?
Judge, this is literally my problem. On May 12th, your trial week, I've got a big docket with Judge Stone for pretrial. I've got a final hearing with Judge Gonteric on a divorce case on the 13th. I've got things on the docket with Judge Stone and Judge Mason on May 14th. I've got a final hearing in a divorce on May 15th, along with mediation in the divorce that afternoon.
I understand, Mr. Notes, but I would think a criminal trial where someone's looking at DOC time would take precedence over a lot of these things,
Judge,
especially in a 2.5-year-old case.
I understand, Judge. I just want, for the record to be clear, I've also got deposition scheduled on the 16th on a criminal case. So it really would not be a great week for me to have to move things around.
I understand, but the alternative is that it's.
Your Honor, may I speak, please?
Yes, sir.
All right, sir.
If you want to speak with your lawyer first before you do that, you can do that.
Directly to you, sir. I would really honestly, me and Mr. Notes, we haven't come to agreements on a lot of things. He's very been disrespectful to me, sir. He's cussed at me during when we was in the legal room and stuff like that. And it's really, there's been a conflict between me and him. And I would really like him to withdraw off my case, sir, because I don't feel like he's looking out for the best of my interests.
Okay.
This case is 2.5 years old. I'm being convicted of charges that I did not do.
Well, you haven't been convicted of anything.
I'm just saying I've been charged with stuff I did not do, Your
Being
Honor.
charged and being
Yes, sir.
convicted are very different things.
Yes, sir, I apologize, Your Honor.
It's okay, I just want to make sure.
I'm just
that we're
saying,
clear.
and he wants me to work this deal with the state, and I didn't do none of this stuff. I'm guilty of, like I told you before, my VOP, I'm
Please,
guilty of that.
don't talk about what you're guilty of.
Yes, sir, I apologize. I would really like somebody else to represent me besides Mr. Notes. Yeah, I don't feel like he's looking out for the best
If
of
we're
my
going to do
interests.
that, because he's been appointed to you, correct? Yes? We're going to have something that's called a Nelson hearing. You know, we can't do that today, but we can try to address that on Monday if we've got enough time for it. But everyone has to be prepared for that. Normally, it's a written request for a Nelson hearing explaining what the circumstances are as to why you think he hasn't done a satisfactory job on your case, so that everyone can be prepared for what that is.
Just when he come to see me the other day, he's telling me he's tired of me. He's wanting me off my case and all that, and he's not looking out for the best of my interests.
Okay.
Tired of me. You're not looking out for the best of my interests on my case. That's why.
Well, I understand that. We'll have a hearing on it where
Yes, sir.
everyone's going to bring any evidence they want to it or any concerns. But this is just not the day for that.
Yes, sir.
Especially when it's just being brought up. Had you filed something previously, maybe.
I'm not good with legal work out. I'm not good at filing.
I'm not being critical to you,
Yes, sir.
Mr. Talbot. I'm just trying to say everyone has needs notice as to what we're going
Yes,
to be
sir.
here for today.
Yes, sir.
And pretrial conferences are not the day to do these things.
Yes, sir.
But we can certainly talk about it on Monday.
But he needs to file something, Judge.
Well, I mean, he's telling me what the situation is now. It'd be nice if you put something in writing, Mr. Talbot, but we won't get it unless he gives it to someone to give to me before then. So that's why I'm trying to let him put it out there a little bit now so we know what the situation is. But typically, I'm not trying to give you advice here, Mr. Talbot, but typically in one of these Nelson hearings, you got to give me specifics, not just, we're not getting along. You got to tell me how that's biasing your case. and then I'll make a determination. But you have to understand as well, and again, I'm not trying to encourage or discourage any particular action by you, is that if I find that he doesn't need to be on your case anymore and assign someone else, it's probably going to take that person a while to get up to speed as well.
Understand
So,
that, and
but that's part of the kind
Yes,
of
sir.
weighing the pros and cons of it that you have to make. I
Yes,
just
sir.
want to make sure you know what they are before you make those determinations. Okay. All right.
Your
So
Honor, we leave it set for trial.
I'm going to put it on as basically,
As I explained, that I would have to get FDLE to rush the testing of the other substance. If the trial is not going to happen, I'd rather give them additional time. That's it.
all right, let's just put it on without subpoenas for trial, and then we'll talk about it on Monday.
That's fine.
Thank you.
Judge, the last case I've got is Ralph Thompson, Thompson, 24 CF 715, 24 CF 2620, 24 CF 2641, and 24 CF 2675. Judge, it's my understanding that he's been, since you let him out of jail, that he's been at West Florida Hospital rehab, and he's been released, I guess. Matter of fact, I talked to pretrial this morning. They thought he was still there, so he must have been released in the last day or so. I mean, I'm not sure.
I got out the 18th.
Oh, you did?
Yes, sir. I apologize, I'm sorry I haven't got up with him yet. Like I should have called him since from there on the 18th, but I was thinking about, I got Dixie Powell on a different on a civil suit, and I was just thinking about getting him, but that would be foolish not to just, since I got him pro bono anyway, I should just go with that. I see what's going to happen.
Okay, so what would y'all like to do today?
So Judge, I don't think I've been involved in this case.
Sir, I do got one question. I'm not trying to make waves or not, but last time I was here, the state said that I scored out to 36 points.
36 points?
Did she mean months, or did
I
she?
don't know. Who's handling Mr. Thompson?
My case, Your Honor, I'm accessing the score sheet to give the answer. 38.03 months. It's months.
Yeah,
not
yes,
points.
ma'am. I'm sorry. That's what I figured. I just didn't know.
Okay. So what do y'all want
Judge,
to do today?
I think I've just been appointed recently.
I think it's in the past month. I see you being assigned on March 31st, so.
There you go. So pretty close to last month. Almost 30, almost 30.
Yeah, sure.
Is that the offer too?
Oh, I don't know what the offer is.
Is that what the offer is, Ms. Leone?
It is.
The guidelines? All right, so what would y'all like to do?
It's got to be continued, Judge.
Mr. Thompson, we're going to set you back on, it's going to be actually June 23rd at 9 o'clock. Do you have the 25 case, Mr. Nopes? 25
Judge, I don't
399?
know that I do.
I've got your name on it, I just don't know if you, just to make sure you've got it. It's a grand theft and a petty theft.
What's that case number, Joe?
25 CF 399.
I'm sure I do, Judge.
Yeah, your name's on it, I just want to make sure you were aware of it. All right, we'll see you back on June 23rd.
Your Honor, thank you for letting me out the other day. I know you're fighting
No,
against
you
it, but
needed some
I've been
help.
doing what I
Make
was
sure
supposed to
you got
do.
what you get-
Thank
what
you,
you
Your
needed.
Honor.
You're welcome, sir. But stay in touch with Mr. Nopes.
Thank you, Mr.
He's handling all your cases right now. All right. Mr. Miles?
Morning, Your Honor. Russ Raymond on behalf of Anthony Miles in case number 173441, and I understand there's a couple other cases represented by different defense lawyers.
Curiosity for Anthony Miles, who's present before the court in 2020, CF 1370.
I get y'all just maybe get to that podium just to make sure you're being picked up. Thank you, Mr.
Yes, sir.
Hart.
And Dustin Harsher, Your Honor. I'm covering this case for Attorney Tony Henderson this morning on behalf of Mr. Miles in case number 19 CF 3289.
And Amy, since you're closest to Mr. Miles, I'll let you kind of start. What are we doing here today?
Your Honor, at this time, Mr. Miles would change his prisoner plea of not guilty and a plea of no contest to the charge of count 1 in 173441 as amended, which is 1 count of human trafficking a child less than 18 years for commercial sexual activity, a first-degree felony, court costs and fines of $10,000. The understanding between the defense and the state is he'll be sentenced to 8.5 years in the Department of Corrections or 102 months, followed by 10 years of sex offender probation. He'll register as a sexual predator. Court costs and fines will be assessed by the court. He has credit for 2,050 days while he was in custody in the local jail as well as in the Department of Corrections. My client's also asking me to ask the court to give him credit for the time he served while he was on pretrial release conditions under house arrest conditions, which he believes are tantamount to being in a work camp in prison. And if the court is inclined...
Being at home is tantamount to prison?
That's his argument he wants me to make, Judge. So that would be an additional 616 days if the court decides that's appropriate. The understanding with the state is all of his other cases that are pending would have a concurrent sentence to run with this sentence. I've gone over the sexual offender probation requirements with him, and he'll have no contact with any of the victims in this case or any of the co-defendants in this case. May I approach?
Yes, sir. Does this cover y'all's cases as well?
No, Your Honor.
Not to my knowledge, Your Honor. I spoke with Mr. Henderson earlier, so I'll address that after you.
Your Honor, I just wanted to double check. Mr. Rady did indicate that he's gone over the sex offender conditions. It is sexual predator designation, I believe it is.
It is.
That's correct.
When was he in DOC that you're claiming some sort of credit?
Your Honor, he was found guilty on November 6, 2019, and was sent to DOC from that sentencing date, however, was on, I believe it was January, but he was in custody from the date of his conviction until he was sentenced, and has been in custody ever since.
What about the...
I'm answering the judge's question.
You said...
What's your date of birth, Mr. Miles?
02/08/92.
The only thing I'm showing on DOC is a release date in 2013. I'm not saying that you don't have a different date, but I don't typically compute that kind of credit for time served. In my looking at it, you've been in the Okaloosa County Jail since November 6th of 2019, which comes out to 2,003 days.
There's also time prior to that awaiting trial. He had about a month before he bonded out, he told me.
More than a month. November to February.
I'm showing he was in custody from December 12th, 2017 to February 27th of 2018.
Jail in November, sir.
Well, I mean, again, typically the jail and then DOC computes these numbers. If you've got a problem with it, I'm going to give you credit for all time served, but I can't say necessarily it's going to be 2,050 days.
Can you please double check? I was in jail in November. I missed Thanksgiving that year. It's a fact.
I'm looking at it right now. December 12th, 2017 to February 17th, 2018. Then October 9th of 2018 to October 11th, 2018. So that's only 2 days. And that's, I'm not quite sure what that is. So it doesn't have a case number assigned to that, but it's only 2 days that we're talking about. So I'm looking at any before 2017, the December date. The last time you were in the Okaloosa County Jail was 2015, which predates this case. So, are you sure you were in the Okaloosa County Jail on Thanksgiving of that year?
Talking about after the trial, that was November.
In which case was that? Yeah, that's 2019. That's what I said. He's been continuously in the Okaloosa County Jail since November 6th, 2019.
No, Your Honor, he did go off the DOC. He was sentenced in January.
January 13th, he was sentenced to 30 years in Department of Corrections.
But he's been in continuous custody since the day the
Correct.
verdict.
What case is that?
That was in 1734-41.
So did it come back?
Yes, sir.
It came back, and there were also some additional charges that came up subsequent to that, so he's been held in custody since the date that the verdict was issued.
My apologies, Judge. I should have given you a little history on it.
It's an 8-year-old case. It's kind of hard to keep track of it all. We're just here for a pretrial conference, but so why did it come back?
The DCA reversed it on count 1 for some errors that they determined that the state made.
Only through hearsay.
Correct.
It would have been a correctable error at trial. They actually laid out exactly how to correct it in the ruling. But based on that, he was returned here for a new trial and has held in custody continuously. So we would agree that he's entitled to anything he's legally entitled to, but we would oppose the pretrial community control being credited as it is normally not credited.
I've never heard of community control or
It was
pretrial. Can I finish? Or pretrial supervision, house arrest. That'd be considered credit for jail time. So we'll get to that because I haven't accepted the plea yet. So he was sentenced for 30 years, and now he's being offered 8.5 years. Is there anything that the state wants to put on the record as to why that is?
No, Your Honor, it's not a downward departure. And he does score to 100.25 months guidelines. So this is the guidelines.
Okay. And has your office spoken with the victim in the case regarding that?
Absolutely, Your Honor. Not with the, I do need to stand corrected. We have not spoken with the child victim. She has made herself unavailable. That was the basis of another charge. We believe, based on the totality of the evidence that is available in the circumstances, that this is the appropriate offer and it is not a downward departure.
And I believe there was also a co-defendant who had received a 5-year plea, right?
Again, I'm just not familiar with all the facts of all the 8 years this case has been pending. I've been in the division for 4 months, so I'm just trying to catch up on it. But that's why when the agreements come in front of me, I have to ask these questions to understand why certain offers are being made. As the state's mentioned, this is a guideline sentence based on what the sentencing guidelines are. Ms. Basso from the state, has anyone asked to be present for sentencing? Okay. Mr. Miles, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Excuse me?
Yes.
You state your full name and date of birth, please.
Anthony Miles, 020892.
All right, and Mr. Miles, you're here in 17 CF 3441. I've been handing a plea and sentencing agreement for you to plead to human trafficking, which is a first-degree felony, punishable up to 30 years in state prison. Do you understand that?
Yeah. Yeah.
Speak up, please.
I need you to speak up so I can hear you, but if the recording is not, we may have an issue. So the plea and sentencing agreement between you and the state that I've received calls for you to do 102 months in the Department of Corrections, followed by 10 years of sex offender probation. You're going to have to register as a sexual predator and do all the, have you talked with Mr. Ramey about the conditions of being a sexual predator designation?
Yes.
Do you have any questions about those?
No.
You get credit for all time served. I don't know exactly what that number was. I know from the November date when you were originally convicted, you've been continuously incarcerated. That came out to 2,003 days by my quick math. As far as the other time, it looked like it may be more than 2 months, so that could be as much as 60, 70 more days. So the 2050 you have on here might actually be shorting you. So what I'm going to do is just say credit for all time served that you've served in jail or DOC on this case. If that number comes up when it's computed by the jail or DOC and you have a concern with that, you can certainly bring that back to the court. But I don't want to say a certain number because, again, I may actually be shorting you. I may be giving you too much. So that's why that's calculated in such a way. And you can come back on what's called a 3800B motion to fix those things if they're not given to you properly. As far as the request that I give you credit for the 616 days you spent on house arrest awaiting trial, that will be denied. So I want to make sure that you understand that before you potentially enter a plea that I'm not going to consider that as credit for time served. Do you understand that, Mr. Miles?
Yes.
All right. I've been in criminal justice for 22 years now. I've never had that happen, unless it was an agreement between the parties in some way. So I'm not going to discretionary do that. As far as court costs, can you tell me what those might be? $867. Have you gone over with Mr. Ramey the conditions of sex offender probation, what you're going to have to do?
Yes.
Do you have any questions about that?
No.
All right. Have you gone over this plea and sentencing agreement with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
You have the guidelines, somebody?
I apologize, we didn't anticipate that this morning, but I can put it on the record, and we'll get that to the court today.
Yes, please. But you're certifying to me it's 102 months is on the guidelines?
Yes, Your Honor, based upon this charge and then his priors, he does come out to 162.2 points. That comes out to 100.25 months.
Oh, it's 102.5.
I'm sorry, I 100.25 months.
100.25? So I have 102 months on here, so.
That's correct, that was our agreement.
The agreement's 102, so it's slightly over by a month and 3 quarters. Okay. Are you satisfied with your attorney's advice and representation in this case, Mr. Miles?
Yes.
Are there any concerns you want to put on the record?
No.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement in order to get you to plea?
No.
You understand that by entering a plea, there won't be a trial of any kind, and you're giving up your trial rights that are listed on page 2 of the agreement that you signed.
Yes.
You understand that you're waiving all potential defenses you have to that charge.
Yes.
You understand that if you're not a U.S. citizen, you can be deported.
Yes.
Is either side aware of any DNA evidence that could exonerate Mr. Miles?
No, Your Honor.
All right, and Mr. Miles, what is your plea to the one count of human trafficking, a first-degree felony punished by up to 30 years in state prison?
No contest.
I'll accept your no contest plea, adjudicate you guilty, sentence you to the Department of Corrections for a period of 102 months with credit for time served. That'll be followed by 10 years of sexual offender probation. You're to register as a sexual predator. I'm going to give you credit for all time served, but I've explained that to you already, Mr. Miles. If there's a concern about what the computation is, you can bring that back for us to consider. I'm not giving you credit for the 616 days of credit that you're asking for while on house arrest. It was $867 in court costs. I'll waive the cost of supervision. Is there anything I missed?
There's a no contact and with any co-defendants, I believe.
Okay. I don't think that's on here, so.
On the second to last page, I believe, Your Honor.
I had to ask too.
Okay, you could just check the boxes there. Okay, I missed that. So also, do you understand there'll be no contact with any co-defendant indirectly or directly, Mr. Miles?
Yes.
All right, I'm going to order that. And I'm going to also order, as checked on the form that you signed, that you shall not have any contact with the with the victim, directly or indirectly. And that's per the request of the victim, correct?
Yes, sir.
All right, and this was the state's agreement?
That is the state's agreement, Your Honor, and I will get the court.
All right, Mr. Miles, you have 30 days to appeal the judgment and sentence of the court. You're going to have to talk to probation because you're going to be released to probation, so they're going to give you some instructions now. And then you have to be fingerprinted as well. All right, thank you, Mr. Miles.
They require GPS.
Yes, GPS will be at $1 a day as part of the sex offender probation.
GPS will be attached prior to release.
Yes.
This is the offer, that's
What are we doing with the other two cases, Mr. Riosti?
I might have a moment to speak with Mr. Miles, briefly. Say, what do you want me to do? Yes or no? So we've got 1,779 days credit for time served. After a long discussion with Mr. Miles concerning these cases, with my case specifically, he's instructed me to withdraw his previously entered plea of no contest and enter a plea of no, and previously enter a plea of no, not guilty to all the counts in 20 CF 1370 and enter a plea of no contest. All of this has been reduced to a plea and sentencing agreement between myself and Mr. Gillespie, who's the state attorney that's working this case. If I might approach, Your Honor.
Yes, sir.
For the record, it's my understanding that Mr. Miles has been incarcerated consistently since June 18th of 2020 on this case, and that he should have 1,779 days of credit for time served.
This is for 8 years Department of Corrections concurrent with the previous case he just pled to.
Yes, Your Honor. Ostensibly, 8 years with credit for time served, with the other F3s being 5 years concurrent.
5 years DOC concurrent and 1 year concurrent.
Yes, Your Honor.
I think out of simplicity's sake, the one misdemeanor, which is count 6, would just be considered time served, because I can't sentence him prison for that. But he's got 11 months, 29 days, obviously, credit for time served in the jail.
5 times over that, Your Honor.
Is that the state's agreement, Mr. Gillespie? Do we have a score sheet for him on that case?
Yes, Your Honor, if I might approach.
Yes, please.
We've been working off of the state's
And guidelines is 70 months. Are these charges related to what he just pled to?
That's correct, Your Honor. Court needs more details, we can approach.
Approach, please. All right, let's approach, please. all of them, so that case would be pretty much over with already. In fact, the third-degree felonies may be close to that point as well. Is that what you want to do here today?
Yes.
You understand to be adjudicated guilty on all of those cases?
Yes.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Are you satisfied with your attorney's advice and representation?
Yes.
I just want to point out that in the certification of the defendant, paragraph 5 on the agreement you signed, it specifically states that my attorney, the court, and the prosecutor have not made any promises, nor have I relied on any representations as to the actual time I would serve if I were to be incarcerated under the terms of the sentencing recommendation, but it's an agreement. So again, as far as the credit for time served, that'll be computed. If you have a disagreement with that, you can certainly bring it back, but I can't promise you what that number is as of right now. Do you understand that?
Yes.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
No.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No.
Did anyone promise you anything other than the terms of the agreement in order to entice you to plea?
No.
You understand that by entering a plea, you're giving up your right to a trial and all the trial rights which are listed on page 2 of your agreement?
Yes.
You understand you're waiving all potential defenses you may have to these 7 counts?
Yes.
You understand that if you're not a U.S. citizen, this would could lead to your deportation?
Yes.
Any DNA evidence that either side knows about that could exonerate Mr. Miles?
No, Your Honor.
Okay, and there's a stipulated factual basis as far as the agreement?
Yes, Your Honor.
Okay. All right, and what is your plea, Mr. Miles?
No contest.
I'll accept your no contest plea to all 7 counts. Again, counts 2, 5, and 7 be 8 years state prison, concurrent with 17-3-441 and 19-3-289. And counts 1, 3, and 4 be 5 years concurrent Department of Corrections, reserve restitution on all counts. Count 6 will be adjudication of guilt 1 year concurrent to those cases. Again, that's 1 year county jail, which you've already served. As far as court costs, $515 will be your court costs, $150 cost of prosecution, $50 PD fee, $100 PD resolution fee. As far as
That would be the $150 cost of prosecution.
well, I think it's usually $100 cost of prosecution, isn't it? That's included in the $515. So it's just the $150 for the PD fee or public assistance lawyer fee. I'm just going to put the $515 on there so we know what that was. All right, and as far as restitution, how long are we reserving on that?
Ask for 90 days.
Okay. I'll reserve on the issue of restitution for a period of 90 days. If nothing comes to the court within 90 days, then that will be considered waived. Anything else that I've missed? This was the state's agreement. Again, I've reviewed the guidelines. Minimum sentence was 74 months, and this would be basically 96 months. So it is a guideline sentence. Mr. Miles, you have 30 days to appeal the judgment and sentence of the court. You also have to be fingerprinted before you leave here this morning. Thank you. Mr. Harsher. Oh, wait, we still have to handle your other case.
Yes, Your Honor. I believe, as it was just announced, I think that case number was just included in that plea agreement. I'm not sure.
It wasn't included in the plea agreement, just that it would be concurrent.
Okay, yes, Your Honor, that's my understanding, and I don't believe our office was made aware of any plea offers or anything today as a result of a consolidation that I think there was a misunderstanding with. On February 14th of 2024, there was a consolidation order in our case, consolidating it with the 17 CF 3441 case. So that was, in, I believe, Mr. Henderson, in my mind, for the purpose of having all cases arrive on the docket on the same day, not for the purpose of what a normal consolidation would be. I don't think there are 2 cases that could be tried together or be consolidated on the issues themselves. So with that being said, I have been advised of an offer from the state that would be concurrent with what Mr. Miles has pled to today. I would just ask that that offer be kept open so Mr. Henderson could have a chance to talk with Mr. Miles about that offer.
We did discuss this was our intent, that it be a concurrent sentence, so the offer does remain open. Since office needs to contact us for any further.
So when do we, what court date do we want to put it on?
Check and see if Monday would be good, Your Honor.
Why don't we put it on, well, are you going to be able to determine that right now, Mr. Harsher?
What's that, Your Honor?
Are you going to be able to determine that right now?
Yes, Your Honor. Monday, I'll be available.
Okay. All right, so it'll be Monday, May 5th, on docket day for purposes of potential plea. All right, thank you.
Thank you, Your Honor.
Ms. Miles.
That concludes my matters.
All right, thank you, Mr. Gillespie, good to see you.
Morning, Your Honor. May it please the court again. Russ Ramey on behalf of State of Florida versus Andrew Delar Rosa, 24-2303. This is a case I had previously filed a motion to withdraw on a good while ago. But when I did that, the state encouraged us to try to make an offer to resolve the case before I got out. We did do that. We engaged in negotiations. Those fell through. And I did reset my motion to withdraw for today.
Were you privately retained in this case?
Yes, sir. We got in, I think, early December 2024.
And who represented Mr. Delar Rosa before that?
I believe Mr. Gibbs may have had it. I don't know if shifted to Mr. Williams prior to Mr. Brady. It was a PD case.
All right, Mr. Delar Rosa, do you have any concerns with him withdrawing?
No.
Would you like me to talk to you about appointing a public defender?
I'm currently working on securing another lawyer.
Okay. In the meantime, what would you like to do?
Yeah, public defender.
Okay.
Judge, the reason we withdrew from Mr. Delar Rosa's case is because there's a co-defendant, and we have the co-defendant.
You have the co-defendant?
I'm sorry, sir.
I thought we had the co-defendant.
No, the RCC has co-defendant.
RCC has the co-defendant.
It's Ms. Lamb. RCC has that one. This is because he went to private counsel.
Sorry, Judge.
All right, Mr. Delar Rosa, I'm going to appoint the public defender to you. You're going to have to fill out another application form just to make sure that it's current and in the file. You can get one of those at the jail. They can give you one of those forms. Make sure you file that. I'm not sure who's going to be potentially handling this. Mr. Russell?
What was the last name, Your Honor?
Last name is Delar Rosa.
Starts with a D?
Yes.
I believe that would be me, Judge.
Well, it's not a third-degree felony.
I know, look at it, Judge. Okay.
All right, can someone step in for now?
Yes, sir. Judge, on Mr. Delar Rosa's case, then at this time, we're going to ask for a continuance.
Mr. Delar Rosa, we're going to put you back on for June 24th at 9 o'clock for your next pretrial conference. Obviously, you're going to have the public defender. If you hire someone else, they'll file something that has the public defender be relieved, and they can take over the case. But obviously, if you're going to do that, the faster you can do it, the better, so they can get up to speed as fast as possible. All right, so someone will come out and talk to you. All right, June 24th. Thank you. Thank you, Mr. Raymond. All right, thank you.
Bradley?
Your Honor, Joseph Riossi for Christian Douglas, who's present before the court in 2023 CF 111C. At this time, Your Honor, I'd like to leave this case set with subpoenas.
It is ready, Your Honor.
It's ready?
Yes, Your Honor.
F111. How long do we think this one might be?
Excluding jury selections, at least 2 days. We have some expert witnesses and several witnesses.
Any other issues as far as discovery outstanding, Mr. Riasti? I know we talked a lot about some transcripts and phone records last time.
I've spoken to several individuals concerning the phone. Your Honor, this case has pended for a long time. I was, I believe, I want to say the 8th attorney that was assigned to this case. And my predecessors knew of these issues. I tried to explore the GPS data. Number one, I don't know if it's there, and number two, it would take months. And my client is unwilling to wait months, but he wants to have the data. So
When you say it takes months, we talked about this first on December 30th.
I've explored all of that. So I'm prepared to I believe that we'll prevail in trial. I've reviewed all the evidence, and I'm ready to go to trial. I need to talk to Ms. Leone about any trial issues, but I'm prepared to take the case to trial.
Okay. Mr. Douglas, anything else that you want to put on the record?
I still ain't received my full discovery. I have partial depositions. I want my medical examiners, everything in my discovery I want. I've been asking
Medical
for
examiner. Is there something from the medical examiner?
No, there's no medical examiner. You may mean medical records.
Medical records?
Okay.
Okay.
Depositions, I still ain't got my depositions. I got, I think, three of the 6.
So, are there any specific ones you want to tell me about that you think you don't have?
I don't have the depositions on the alleged victim, one of the alleged witnesses.
Were there depositions taken?
Yes, Your Honor, there were.
Do you have the transcripts?
We have transcripts.
Do you have them, Mr. Riasti?
I have the transcripts, yes, Your Honor.
Why haven't they been turned over to your client?
Uh,
I've gone over the transcripts with my clients. And I've gone over the evidence with my clients. I'll go over them with them again. I'll provide them the deposition transcripts.
So are you just asking for a copy of them, Mr. Douglas?
I haven't seen them, period, sir.
I'll make sure he has all the deposition transcripts.
Have you gone over them together?
No, sir. Also, the issue with the phones, Your Honor, if I could say something.
I mean, we've talked about it every time you've been here. That's why I keep bringing it up.
The state clearly admitted to having them on, I think it was December 30th. Said we have phones, we have no objection to turn them over to my counsel. Then the following court date, state says, this is the first they heard about it. We don't have no phones. You contradicted that when you said you keep notes of all your cases and said that continuous was for the retrieve the data off the phones. It's not just the GPS, there's messages in the phones.
Well, but that has to be explained, and that's why I've been asking these questions every time.
Well, I'm leaving it
Mr.
up-
Douglas?
Yes, sir.
I've asked every time we've talked about quote-unquote phone records, what exactly is being looked for and what's missing. Last time we talked about is GPS. That's all that was talked about. Now you're telling me there's phone messages.
I leave it in the hands of my counsel for the most part, and he's not coming to see me.
What have you done about those things?
I've talked to Ms. Leone about receiving them, and I've talked to a phone.
Okay, let's just start from the beginning then. Are there phones allegedly belonging to Mr. Douglas that are in the custody of the state in some way?
No, Your Honor, I don't have those phone downloads. There
Okay,
are
but-
text messages present in the case, but they're like screenshots and witnesses who would testify to those.
Okay, so last time we were here, Mr. Douglas, I think, said something about the fact that he had 3 phones and they were taken by law enforcement. Where did they go?
they may be kept in evidence, but there was no phone download.
Well, I
down to them.
understand, but then if if there are phones there, Mr. Riossi, what are you doing to get those phones looked at?
Tried to figure out how to get the phone downloads done. I was told that it takes months to do that. And
Who told you that?
I talked to a phone expert on it.
I mean, it can be, my experience, it can be done in a day.
That's correct, Your Honor.
I mean, what they usually do, they put it on, I don't want to say a machine to dumb it down, but that blocks it from being written on, but it copies the entire contents of the phone. Trust me, I remember when I was a lawyer being handed or given a thumb drive that had literally every single thing that was on someone's phone and spent 8 to 12 hours going through those things because it takes everything off the phone. But they can be done in the same time you could, format a hard drive or copy a thumb drive. It's not a long process.
Well, then I'd ask that this case be continued so that I could receive.
We've been here 3 times now, Mr. Riossi, where you've talked about the same things, and I don't think you've said anything to me in the last 2 times that makes me think you've done anything since the first time. If they have phones in their possession, in evidence, and you want to get to them, it's not hard to do. But what you're telling me is it hasn't been done. Why hasn't it been done?
Other than I've had a lot of cases to deal with, and I've been.
Well, and I understand that, Mr. Riossi, but the last time we were here, I said the same thing to you. If you got too many cases, you need to tell us to stop assigning you cases. Because, you're a private defense lawyer who chooses to take these things. And if you've got too many, then you need to say, take me off the list.
Well, I intended to have this case ready for trial, and I believe that we currently.
But what's something that your client is telling you is very important to his case, you haven't done anything in 4 months. What are you asking to do at this point, Mr. Douglas?
I've asked several times for him to file motions, like a motion to suppress, a motion in limine. No motions have been filed. I don't know if it's an issue, like you're saying, he has too many people on his caseload, he's too busy, but he ain't made time to come talk to me, go over my case clearly.
Are you requesting anything from the court?
I just want to resolve the case, Your Honor, in a fashionable manner. I've been here 28 months, entirely too long.
How long have you been on the case, Mr. Riossi?
I believe I was appointed in the fall of 2024, Your Honor. I have been deceived, Mr. Douglas, but
This is what we're going to do. We're going to leave it on for docket day on Monday. See if y'all can figure out any of these discovery issues. I wanted you to tell me what you've done in the meantime, Mr. Riossi, but I would fully be prepared to go forward with a Nelson hearing at this point. We'll see you on Monday, May 5th.
We are set it without subpoenas.
Without subpoenas at this point, but, I mean, you can't ask to be assigned to cases and just, being told by you, Mr. Riossi, that you haven't done anything in 4 months. And this is why I take the notes, so that
Yes,
when
sir.
you say you need phone records, and then I question you on that, what exactly do you mean? Then we come back 2 months later, it's the same conversation, and now we're here for a third time, it's the same conversation. And now he's telling me you haven't filed motions he's asked you to file, you don't see him in the jail. I just don't know what else we can do at this point.
This is my, I think, fifth or sixth attorney on this case. It's just, I'm ready to resolve
I
it.
understand. I mean, I'm not sure why those other attorneys were on and then off. Again, I didn't take over the case until that December 30th date that we've talked about was my first day on the case, and I've tried to push this case since that date, or starting with that date, to find out what was needed. And that's why I try to pay attention to these things as to what else needs to be done. And what I'm being told is none of the things we've talked about have been done. All right.
You know, just for the record, I would like the record to reflect that it's overstates objection to continue. Because I'm also looking at the last minute sheet from last pretrial. The court announced that that was going to be the last continuance. So.
I mean, I can put it down for plea trial, Ms. Leone, but depending on what happens on Monday.
No, I understand, Your Honor. The reason why I'm insisting on placing my objection on the record is because at 3 times, then the state can ask for speedy trial. In this case, it's very important because the health of the victim is worsening as we're speaking. And it may very well turn into, I hope not, into a murder instead of attempted murder because of the consequences medical consequences victim is facing due to this incident.
Okay, I'm going to leave it set for with subpoenas. We'll talk about it.
Okay,
I mean,
yes,
it's
Your
only a
Honor.
few days from now that we're going to come back and talk, but I'm going to need to know what's going on in the meantime and whether or not Mr. Riasti is going to continue on the case or not.
And if I may ask, that if he gets set for trial, that it be set for the second week, because I would have to subpoena all the medical personnel from Pensacola and all of that.
I mean, I'll do my best. As you know, we've got some pretty big cases already set for trial for that 2-week period.
I understand, Your Honor.
I mean, I'll put it down that you want the second week, but I know we've got one that's already asked for that week. We've got several others that are going to have to be tried. So we'll kind of see how it pans out.
That's
but
fine, Your Honor.
It shouldn't be a problem if we need to. I'll do everything I can. All right, Mr. Douglas, we'll see you on Monday.
Yes, sir. Thank you.
Your Honor, as Mr. Ramey approaches, may I also approach the court with a score sheet in
Sure.
Miles' case?
Please, the court, if we could call back, although Mr. Miles is no longer here, I would waive his presence. I neglected to ask the court to recommend Paula CI as a placement. I had talked to my client, that's merely a recommendation, it's up to DOC.
I'll make the recommendation for Wakulla, but I'm not sure if DOC will agree with me, but.
And Your Honor, I did show that to Mr. Ramey first, the score sheet, and it does reflect what I put on the record earlier.
And he received 102 months.
Yes, sir.
All right.
Thank you, Your Honor.
All right, thank you, Mr. Reamy. Mr. Riasti, is this your client?
No, Your Honor.
Your name, sir?
Bradley.
Got you listed as his attorney, Mr. Riasti. You may be newly assigned to it. Okay.
I would ask
It looks like,
that
well, it was done on March 26th.
March 26th.
Showing your email address it was sent to, but this is David Paul Bradley, 24 CF 1841. He's here charged with aggravated battery using a deadly weapon.
I don't have a file on this case, Your Honor. Every time I get a case that comes in, I create a new file and do a workup on it. I don't have a file on this one. I'm not sure why this case was. I don't show. I'd ask that the case be continued so that I can meet with my client.
You know, I was ready to extend an offer that would release him from jail, although he scores, but it
Why don't we
was
pass
for
this case, Your
probation.
Honor? Could we pass this
Pass
case?
it today?
No, pass it for a moment so that I could speak.
Yeah, pass it for later today is what
Yes,
I
Your
meant.
Honor.
I'm sorry, yes. All right, we'll bring you back, Mr. Bradley.
Okay, thank you.
Sounds like there might be a plea offer. He'll come talk to you about it and then see if you want to resolve it today.
Your Honor, Kelvin Ford, I'm in the process of working out an agreement with Kelvin Ford.
All right, let's pass Mr. Ford until, Mr. Ford, sounds like they're trying to work out some agreement for you.
I just wanted to ask you guys know my wife will be seen today, her name's Angela. I didn't know if it was okay to ask or not, whatever.
If she's on the docket.
This morning, whatever. I didn't know if it was, okay, she's.
Okay. All right, so I think that concludes, other than Mr. Riosi's two we just passed. I think we're done with private counsel and RCC. Do y'all have any issue with taking about a 20-minute lunch break?
No, not at all, Your Honor.
No, Judge.
I know everybody wants to get through things. If y'all need more time, I can give more time, but it sounds, I know.
8:30 if you give it.
Well, I guess just maybe talk amongst yourselves as to whose cases y'all want to call up first. So if you need a little bit more time, maybe someone who doesn't can start calling their cases, and we'll get the ground running at 12:45.
Kind of easy on it. I just want to grab a quick bite or something.
This is 766.
All right, I'll be ready to proceed when we come back, Judge.
All right, let's take a break until 12:45.
Thank you, Your Honor.
All right, thank you.
F2L7.